Permitted to mention a matter, my lord. On Wednesday, I have left the court due to an emergency at my house, my lord. A matter has been called on, my lord, and it has been out of the list, my lord. Very urgent matter, my lord.
Mention.
Much of
Hand over the.
Permit to mention, Lordship, the matter is before the learned trial court tomorrow, Lordship.
Yes.
Now, earlier court time, I have mentioned the matter, Lordship.
Hand over the slip.
Kindly consider in default, Lordship, it is last chance, fixed as last chance, Lordship.
Yes.
My lord, may I be mentioned? My lord, the interim order is expiring on the 14th of August.
Hand over the slip.
No oblige, my lord.
My lord, this matter was come 23rd July. My lord,
Please use the microphone. Please use the microphone.
my lord, this matter came on hearing 23rd July. But if direction was given, the matter will come in motion stage in 1 week, within a week, but not a till date not come, my lord. Kindly.
Hand over the slip.
The Lordship may permit to mention two matter for release here, Lordship.
Hand over the slip. Yes, call the list.
My lord, for release, your lord.
No, may it permitted to mention for inclusion in the list, my lord.
Please come on Wednesday. Yes, call the list.
My lord, may I have a kindly mention, Lord? This matter was taken up. I have challenged the section 45.
Section?
CBC. Section 47 order of passed by the Barasat court.
Yes.
Section 47. My lord, the matter was appeared before Lordship. On that day, I was before my lord justice, Sobbosari Bhattacharya and circuit bench. My junior mentioned the matter for not to. Now, matter is fixed on 13.
Yes.
And my lord passed an order that adjourned, but that shall not preclude the learned court for execution of the case. So, my lord, the matter is 13.
Hand over the slip. Yes.
My lord, when the matter will appear, my lord?
Please hand over the slip. I will call. Yes, call the list.
With notice.
Item number 1.
My lord, I appear on behalf of the
The wife petitioner, Lordship.
Yes.
So, the
My lord,
2019 law court directed to pay 15,000 per month. Till date, 8,49,000 is due for the wife, Lordship. And this matter was appeared before Justice.
Section 24 চলে এলো।
Lordship, the wife petitioner, Lordship.
Yes.
This is the last order.
It has been assigned.
No, it is assigned in this one. There is another two matters in your Lordship
yes.
list. Lord's monthly list, Lordship, 302 and 203. But the wife, Lordship, still now 8,49,000 is still pending. 15,000 per month directed by the trial court 2019. Thereafter, there is the situation the wife cannot survive now. Lordship, kindly fixed or anything. Or today, Lordship. Till today, 8,49,000 is due.
Where are the other matters appearing?
Where are the monthly?
Yes, 302 and 303.
In the 302 and 303
of the
at
month.
motion stage.
Motion stage.
My lord.
Motion stage. One is execution, another
What is the challenge in this civil division application?
is civil division, Lordship. The court directed 15,000. Against that, they have paid for an appeal. There is another appeal division. Another division is pending.
Challenging the order of alimony, they have
filed. But
yes.
In this application, I have filed in trial court that they are not paying, so you stop the main suit, direct me to pay this. Against that, the lower court directed that you proceed the execution case without staying there. Against that, I have come here. Thereafter, I have filed execution case. That case also stay by this another revision before the lordships.
The matter was sent before
The
mediation
execution
stayed.
case, I think lordship subject to lordship is appealable order. But that has been
which is the appealable order?
The execution we have filed.
Yes.
Against the order.
Yes.
Against that.
By appellable order?
The order 21 rule 54. Attachment of the property subject to lordship consideration.
An attachment order has been passed. Where is the order of attachment?
21 rule
We have filed an application, Lordship. Kindly see.
No, but by the order impugned, no order of attachment has been passed.
No.
So,
in this case?
In this right, the order application for order or attachment is first filed before the trial.
fine, no order has been passed.
No
Then
order.
it is an appellable
Is
order.
that ওর এগেনস্টে তো ওরা অ্যাপিয়ার ছিল
হ্যাঁ।
ফাইল পাস করেছিল তো।
হ্যাঁ।
They have passed. Against that, they have come in the another division application. I think 302 or 3. And the Honorable Justice Basu, Vishwajit Basu directed me not to take any steps because the matter was referred to the mediator. Mediator fell.
Sir, let the
That's
three
a very
eviction
urgent
applications
matter,
be
Lordship. Kindly.
updated together, my lord.
Not getting any maintenance.
8,49,000 is still pending. Lord Malva.
Which next to supplementary.
Attachment attach করেছিল না?
Seen the
I think আমার একটা কি আছে তো না। Not in the supplementary list.
19th monthly list will
Yes,
not
yes.
be
No, I
published
am
in the
extremely sorry. I am extremely sorry.
Yes, next.
Slip of tongue.
Item number 2.
Milord, I am the petitioner appearing in person, Milord.
Yes.
Milord, I filed this application for cancellation of Wakalatnama under Rule 72 of Chapter 5, Milord. Your Lordship, if I may request your Lordship to kindly see page 12 of my application, which is Annexure AA. The annexure in
Standard advocate has not given no objection Wakalatnama.
No, Milord, despite multiple emails, phone calls, all of these are annexed, Milord.
Petitioner is directed to serve a copy of this Can 1 of 2025 upon Mr. Orijit Bera. Upon
Orijit Bera, yes,
upon
Milord.
Mr. Orijit Bera, learned advocate, and file an affidavit of service on the next date. List this matter under the same heading on August 21, 2025. Yes, next.
And Arunangshu Chakraborty, Milord, if you may. He's the senior.
Senior, you do be senior has not accepted the Wakalatnama. You do. I have directed you to serve upon the learned advocate on record. Yes, who is appearing in this matter? Item number 3. It is correction, naki? Correction does not tally with the petition. দেখে নিন কি কষ্ট রাখলে কি গন্ডগোল আছে বলছে।
praying for a short.
I'm
Uttam Mukherjee is appearing for the petitioner. He's on his way. He could not come because of the traffic jam, Lordship.
Pass over next.
Malik.
Item number 5.
My lord, I appear for the petitioner, my lord. This is appearing effectively, my lord, at my instance, my lord. It is that matter, my lord, where the original rule had been sent to the district judge's office, my lord. The report, my lord, was called for from the office of the district judge.
You have not approached the office of the district judge for getting that copy. That's the report.
My lord, I was not required to because the district didn't in any way. If it's so, my lord, pass a direction to that effect that it may be handed over.
Yes. Have to approach it has been sent to.
Because my lord, the district delegate was not supposed to send it. That is the order.
Unnecessarily you are filing. Look, this has been delayed for this. You could have approached the district judge when you have seen for return of that.
Very well, we'll do that. My lord, kindly also directs that the petitioner may be at liberty to approach the district judge's office.
This application under Article 227 of the Constitution of India is at the instance of yes, Mr. Ghosh.
I'll start the copy from the address of the opposite party wife. Because the address of the opposite party wife has been mentioned in the matrimonial application. I have start copy from the opposite party as well as at the address of the parents' residence. Also has interfered with the order of the counter maintenance. Also directed me to pay the areas of maintenance from the August 2020. I am complying with the order. I have brought the reposited challenge. Strictly, I am complying the lordship's order.
If it is service file, what happened? What is the endorsement?
Intimation, final intimation.
Unclaimed.
The two places I have served.
What is the other endorsement?
That is the
That is insufficient address.
Actually, address mentioned by the wife in the matrimonial proceedings 108 Taliganj.
The if it is
Praying for the Passover, my lord.
why, sir? No Passover. Please start.
In the jam, the stocks.
Matter, your lordship will find previously there was the direction from this Honorable High Court that matters should be disposed of within 1 year. But in that case, the defendant, the opposite party herein, took several times. Thereafter, they completed PW1, thereafter PW2. After taking PW2, they took and 1 month time because their lawyer will come from Bombay. Thereafter, after lapse of 1 month, they have filed this application. This matter go to commercial court. Lord, we played before the trial court that before trial, if that be so, then matter should be due the attention of the learned court before trial. But here is PW1 completed.
So, sir, is it a commercial dispute?
No, my lord. No, my lord.
Show me the suit. What is the suit for? Please show me the place.
Recovery of money, my lord.
Yes. So, suit for recovery of money. What amount?
4 crores.
Yes.
4 crores.
What's the dispute? What is the transaction?
Dispute is we have got a film show, postmaster.
Show me your objection to the transfer. Transfer application, show me your objection that you have said that it's not a commercial dispute. Show me that. So if it is a commercial dispute, the ordinary courts cannot decide this. By virtue of a statute, it has to be transferred.
This point, neither they have taken before the honorable court.
Maybe, sir, but it's a statutory requirement. Otherwise, this will be a nullity. Cannot be decided.
It is not a commercial transaction at all because of the fact your lordship.
Satisfy me on that. Satisfy me on that.
Appreciate. There was a song in my film, Gayer Budu. This song has been used by the G Enterprise. We have repeatedly requested them not to use. First time they admitted that we have.
Show me the plaint. Show me the plaint.
Plaint, my lord, I have already filed it. This is my plaint, my lord.
So this falls within 2(1) C(17) intellectual property rights. That is the suit for. And if it is the claim is 4 crores, that's obviously above the specified value.
We submitted one judgment of the Honorable Bombay High Court, wherein this categorically stated if it acted the commercial transaction, that point should be raised at the first time. But after the trial, this point cannot be considered.
Show me that decision.
That judgment, I told my client to bring it yesterday. At the time of trial court hearing, we submitted that judgment. But I can submit the judgment if your lordship permits me one day time. Because I asked them to bring that judgment.
Come at 2 p.m.
As your
2 p.m.
As your lordship. Duraswani has been to that.
Yes. Take back the plaint. Produces 2 p.m. Yes, next.
As your lordship.
Item number 8.
Can it be fixed upon tomorrow, my lord?
No. Yes.
Praying for a short passover.
No, madam. Please start.
The lordship.
Yes.
Senior is in another matter. Kindly pass over for.
Yes.
For the caveat, my lord, opposite party.
Yes.
By the order impugned, my lord, while disposing of, my lord, the misappeal, my lord, which was preferred against the refusal of ad interim order of injunction, my lord, the court has granted, my lord, an order of status quo, my lord, and directed the learned trial court to dispose of as expeditiously as possible the application under Order 39, Rule 1 and 2.
Yes. Yes. Who is your senior, madam?
Advocate Debashish Mitra.
Yes. Ask him to come at 12.
Lordship.
Yes. Next.
Item number 9.
My lord, Mr. Harvin Banerjee is appearing on behalf of the petitioner, my lord. He's in the way, my lord. They got in the traffic jam. The kindly short pass of my lord. Praying.
Passover. Next.
Item number 10.
My lord, in this matter, I am paying for a short passover. I am not in this matter, my lord. I have been instructed, my lord. But he is away, my lord. My lord, kindly take it on at 12. Come.
Passover. Next.
Item number 11.
Yes.
Also, I am led by Mr. Parthobotim Rai.
Yes, please start, Mr. Boni.
I believe this is a suit.
Yes.
Not under Section 6 of the Specific Relief Act.
Yes.
For restoration of possession. I was dispossessed. The agreement of tenancy was there. It was been executed in the year 2015. suppressing the fact that 2014, a suit inter se between defendant number 1 and 2 with 3 was going on. And in that suit, a specific order was there restraining the defendant, the landlord, to alienate the property for 25 years. Now, superseding that agreement, my lord, that order, the agreement has been executed.
Yes.
And however, my lord, I was not aware of that kind of order. Now, when I was in my possession of the shop room, I was doing my business therefrom from the year 2015. All on a sudden, in the year 2022, I was dispossessed. Your lordship kindly sees the plain first and the prayer portion of the plaint. Page 24. Defendant number 1 and 2, who are inducted me as a tenant, they did not appear thereafter. But the defendant number 3, who got the order of injunction, page 24.
Yes. Yes.
May I read, Lord? A decree for declaration that the plaintiffs are bona fide joint tenants at one shop room and one storeroom situated on the ground floor of premises number 78, such and such, under the defendants and or their heir, legal representatives and or assigns. Decree for recovery of hush and vacant possession of one shop room measuring about 400 square feet and one storeroom measuring about 300 square feet from such and such, by evicting the defendants, their manor agents, servants, their assigns therefrom. Decree for permanent injunction restraining the defendants, their men, assigns, and demolishing and damaging the premises number such and such. B. Decree for mean profit of 5,000 rupees. Decree for recovery of value of stolen furniture, because after the dispossession, my articles, my furnitures were there which were stolen. That amount is 20 lakhs and odd. These are the prayer in the plaint. Now, defendant number 3, my senior has come.
Yes. Yes, Mr. Rai.
What are the issues? As on this, there is what are the issues framed? No issues framed. Now, my lord, it requires, my lord, the fixed under Order 40 Rule 2. Whether the Order 40 Rule 2, the mixed question of law and fact, whether that can be taken up as a.
Cannot be taken. You are right.
Here, my lord, what are the case made out? I have been inducted in respect of the property.
Mr. Rai, if the learned trial judge feels it is a question of law only,
I could have understood that.
It should be decided. If the court feels no, then trial will proceed.
My lord, can you consider? If that be so, what is the finding? I bow down to your lordship. What is your lordship?
Yes.
Your lordship only takes up the order impugned.
Yes.
The plaintiffs have stated in paragraph 5 from middle portion, my lord will find.
Yes.
Plaintiff they are inducted defendant number 1 transfer the shop room by an agreement for tenancy dated such and such. The Honorable High Court by order dated such and such restrained the defendant number from selling, alienating, encumbering, disposing, party in possession.
What is the relation between defendant number 1 and the defendant number 3?
3 is developers.
And defendant number 1?
1 is the landlord. Landlord, there is agreement, be as it may from between them. So today, my lord, if this document can be automatically exhibited without evidence, my lord can record that it can be very hard without any, because
Mr. Rai, only the learned trial judge has recorded.
Yes, on the basis of this.
An issue, let the trial judge proceed with that. If the trial judge finds yes, cannot be decided, it will be, the suit will proceed in accordance.
Basically consider when the court is of the opinion, these are the documents required for the purpose of adjudication. Whether this, unless until these documents are exhibited, whether it can be preliminary issue or not.
What document is to be
Yes,
exhibited?
Kali, the Honorable High Courts by order such and such and restrain the defendant from selling alienated income by this.
It will be automatically
Subject to caution, my lord. Subject to caution, my lord, my lords. Judgment I will satisfy your lordship. It is not automatic.
Yes.
It is not a public document in that sense.
Yes.
My lord, then my lord can record that this is a public document. It can be.
Mr. Rai, take all objections. All points will be available there. Raise all objections there that this cannot be exhibited. Otherwise,
If you logically consider,
only the trial judge has fixed the preliminary issue, it will proceed. Nothing has been said. It will be entitled to raise.
You should be under order 40 rule.
He will be entitled to raise all points there.
My lord, can you consider order 40 rule 2? Whether the court is of the opinion, it can be hard on the point of law.
Show me your plaint.
Yes. And you turn to page 12. It starts on page 12.
Yes.
Oh, prayers. Can you turn to page 18, paragraph 12 onwards?
Page
18, internal page 7,
yes.
paragraph 12 of the plaint. The cause of action for the purpose of filing of this suit. On the face of the plaint, if you logically consider whether it is maintainable or not. This is a list of things.
What is the relief claimed against the defendant number 3?
No. Restoration of position. If you logically,
what is the cause of action against defendant number 3?
Defendant number 3, you logically consider paragraph 16, paragraph 15.
Yes.
The first time in the writ application, he entered appearance.
Yes.
Is developing company and trying to construct a multi-story building.
No, what is the relief claimed? What is the cause of action against
defendant number 3? I have been evicted by the defendant.
What is the cause of action against defendant number 3? Only you have said that he appeared in the writ petition, you have impleaded. That cannot be a ground. What's the cause of action in the suit against the defendant number 3?
I said the defendants have evicted me from the property. Forcefully.
Where is that? Show
Consider...
me your
Yes,
allegation against defendant number 3.
Yeah, logically turn to paragraph 19. The plaintiff and their son immediately came to and found that all the goods are removed from the shop. So defendants also remove all the locks of the plaintiffs from the suit property and place defendants put their own locks. The plaintiff requests the defendants main and agent.
There are no cause of action against defendants. You have made it vague. Show me a specific cause of action against the defendant number 3.
I have been inducted one of the party. Yes. Been inducted by one of the party.
Your suit, Mr. Rai, your suit is for declaration of tenancy, right? So who are the necessary parties in a suit for declaration of tenancy?
And the person who is claiming to be entitled, who is threatening also.
Show me that.
That is why Minor Kali consider. That is why Kali apropos to this paragraph 15. That he said he is.
He is only appeared. One to expeditious.
The said entered evidence file documents after hearing all the parties such and such. Plaintiff said the plaintiffs on the writ application for this honorable court came to know.
According to you, joint tenant with whom? These two plaintiffs are the joint tenants. So inducted by the defendant number 1. So what is the relation between defendant number 2 and you?
His son.
No relation. In a suit for declaration of tenancy right, son cannot be a party in a suit for declaration of tenancy right. Son of a owner cannot be a necessary party.
My lord, can you consider Shankar Prasad Garg and Surya Prasad Garg are the father and son.
Son is collecting rent.
Because the son is collecting rent, that's why he has made party.
Where have you stated that? Son is collecting rent, he is the landlord.
Your lordship, on page 36, I have annexed.
Page. No, from the plain. Please show me from the plain to your averment.
Paragraph 3 onwards, my lord. The defendant number 1, Shankar Prasad Garg, is one of the co-owners of the premises of such and such. And he had to
Paragraph.
3 onwards, my lord. Your lordship,
Yes.
The defendant number 1, Shankar Prasad Garg, has right to induct and evict the tenants of the said building. The defendant has right to repair. By the agreement of tenancy dated 25th November 2015, the defendant number 1 inducted plaintiff as a joint tenant in respect of one shop room measuring such and such. In terms of the mentioned agreement tenancy, payable to the tenanted premises situated premises number such and such. The defendant number 1 all along received rent from the plaintiff without an objection. In the year 2017, the defendant requested the plaintiff to pay the monthly rent for the suit premises to his son Surya Prasad Garg, since he was unable to receive rent from income tax purpose. The plaintiff started to pay rent in the suit premises to defendant number 2. The defendant number 2 in the month of 2023, June, informed the plaintiff they are unable to collect rent from the plaintiff. The plaintiff has started depositing monthly rent in the office of the rent controller to the credit of the defendant number 2. In terms of the agreement tenancy, were permitted to get electricity.
All along, defendant number 1 was receiving rent.
Up to 2017.
Thereafter, defendant number 2 started
My lord is
receiving rent.
considering to the plaint as it is.
Yes, as it is.
As it is.
I'm also looking at the documents also. I'm only going by your plain averment.
Consider. As of this day, whether so therefore, my lord, I might be in a loser side. My suit will be dismissed with cost, everything. Whether without evidence, this order 14 rule 2, read by the learned court will can be considered or not. Only the defendant number 3 is appearing. 1 and 2 is not coming. So whether this
defendant number 3 is appearing, has filed the written statement.
Yes.
Show me the written statement filed by the defendant number 3.
It starts from page, that is page 81.
Yes. Show me the positive case of the defendant number 3. Any right he has claimed in respect of the property?
Yes.
Yes, what is the right? Please show me that.
এমন করে করেছে না এগুলো 1 2 3 4 9. If you logically turn to paragraph 82.
Paragraph 82?
No, page 82, page 82, paragraph 9, sub para 1.
Page 82, paragraph 9.
After that manner,
paragraph 1, yes. I, yes.
Defendant number Shankar Prasad Garg along his father, Shakti Prasad Garg jointly and undivided 1/4 share in the said premises comprising of such and such. The agreement Bhupal Prasad transferred, and after that he purchased the property. The suits were filed. After that, your lordship will find the purchase portion. My lord, I'm drawing so the purchase portion. Can you turn to page 91, 20?
Specific performance of contracts filed. So now
there, everything position.
Suits are there or suits have been decreed?
Some suits are decreed, some
specific performance
decreed.
So by virtue of that,
then one has to consider,
and 2.
Then to consider the statement made in the statement and the documents itself.
So that is the,
Now the defendant number 3 about causing searches to be made in the records of additional register of assurance, page 91.
so yes, this
Came
is
to
the,
the land and Song
so
Corporation
this is
got.
the reason why defendant number 3 has been included. Not very clear in the plain, very clear in the
That is why, my lord. What is followed from your
Now
law?
I know the reason. That is why I was asking you why the defendant number 3 was
Interest holder, the developer, once I submit the
developer now, Mr.
No,
has
that is why
purchased. He has become the owner.
Page 20.
He has become the owner now.
Preemption section 4. Partition suit is
That
the
is
defense.
with regard to the other as portion.
No, this was also stranger that was also challenged. Those are there, my lord. Can you turn to page 20? Defendant number 3 about causing searches to be made.
By the order impugned.
Item number 10 minus short password.
Paragraph 19. Whenever lordship is this side.
I'm not bound by that, Mr.
At least was a Supreme Court judgment to some extent.
No, I'm not saying I'm not bound by the Supreme Court judgment. I'm saying that I am not bound by the.
Yes, now.
Which are-
At that point of time,
Yes.
just paragraph 19.
Yes, call the next matter.
Earlier matter, my lord, I.
Yes, please wait. Yes, call the next matter.
Item number 12.
Sir, I am for the petitioner, filed a revision application.
Yes.
Lordship, I am appearing for the opposite party landlord. The copies
Yes.
has not been served upon me.
Sir, actually, due
This is
to
the
the
caveat. You have not lodged the
No,
caveat.
he has sent me a notice, unsigned notice. He has sent me pictures of the petition only, but otherwise I don't have any.
Sir, actually, because of the technical glitches from the post office for the last 8-9 days, I called upon my learned friend and informed him that today the matter will be listed. And
All right.
I
Yes,
sent the
please
soft
proceed.
copy.
Please proceed. Yes.
That is all. Your Lordship, this is basically a revision application against the order of a fourth presidency judge, fourth bench of the presidency small cause courts. So this basically is an application which was filed against a rejection of Order 7, Rule 11. My lord, there were technically 2 points in it. Number one is that they filed an eviction suit. Now in that eviction suit, they made default of rent as their most important point. Now, once this was discovered that there was an...
They are the tenants.
We are the tenants. So we are the tenants.
You have not paid.
Yeah, I'll just tell you, sir. Basically, there was a Section 21 application which was filed even prior to the eviction suit.
For depositing rent before the rent controller.
Absolutely.
Yes.
Now, that fact was not stated in their petition. Now, we discovered that...
What is the suit for?
Suit was for eviction. And
under Section 6 of the West Bengal Premises Tenancy Act.
Correct, sir.
Yes.
At that point, one of the important determinative factors was non-payment of rent. But however, they were contesting the suit under Section 21 of the Rent Controls Act. I mean, under of the learned in the court of the learned ARC. Now, what happened once we discovered this fact? We filed an Order 7, Rule 11. There were two technical points. Number one is suppression of facts, omission of material facts, which comes under the basis of Order 6, Rule 2. Omission of a single material facts lead to an incomplete cause of action, and an incomplete cause of action leads to suppression of material facts, which can be a relevant ground for rejection of the suit. There are umpteen number of Catina judgments of the Honorable Apex Court as well as the Honorable High Court as well. This was one of the points. Second point was basically that this was a tenancy which was used for running businesses and for trade and businesses. Now, once in their plaint they disclosed this fact as well, that this property was used for trade and commerce of business. Now, once this fact is as per the Commercial Courts Act of Section 21C, so this is particularly a commercial suit. Now, there is a judgment of Honorable High Court also regarding this, that the learned trial court will not be able to continue this suit. They need to transfer this suit once this fact is being obtained. Now, two important facts is required for this. Number one, the premise, there has to be an agreement, and the premises is used for trade and commerce, which is all disclosed in the plaint itself. So once out of these two, there is no third condition which is need to be required. If you look at the order also, which was passed by the learned presidency small cause court judges, they had taken an erroneous interpretation of law, which says that this premises, in order to seek a commercial suit, the landlord has to be into commercial relationship with the tenant or with the third person, which was never the fact. My lords, the Catina of judgments in Supreme Court has never disclosed these things anywhere. In our written notes of objection, which we filed on 16/6/2025, we filed the Catina of judgments. The learned trial court has quoted those judgments as well, but failed to take any import of those judgments. Now, they had quoted those judgments, but in spite of taking those judgments, they have taken an erroneous interpretation of law. So there are a lot of judgments, Your Lordship, we already have. I have also not brought many judgments, but the most relevant recent judgment is also there of the learned High Court. This I have not brought it today, Your Lordship. Unfortunately,
why have you not brought?
Sir, unfortunately, because of the haste situation, I had to. Because of certain haste situations, like all those judgments were quoted as. In fact,
please refer to those.
Yes, on the next, probably I can. If a short date.
After some argument, the learned advocate appearing for the
My lord, I appear for the petitioner. Yeah, now.
Yes.
My lord, the order impugned is 3rd of July 2025, passed in a suit for eviction on an application taken out by the defendant saying that I don't want to continue because the previous order of the, my lord, court directing occupation charges is, my lord, onerous. In any event, I have shifted. I am not, my lord, running my operations there. This is the application. My lord, we also, as the plaintiff said, that the application can be allowed.
You are the plaintiff.
And the plaintiff.
Yes.
Date and time can be fixed. My lord, the learned
don't want the occupation charges.
No. Occupation charges is pending. That will continue, my lord. That order is also there. Defendant files an application under 151 saying that I don't intend to continue in occupation of the property.
Yes.
Prayer is that fix a time and date for handing over of possession. And the suit for mean profit and what, my lord, the other reliefs, my lord, area dues will continue. My lord, we did not oppose. The learned judge, by the order impugned in internal page 2 records, parties are directed to take steps in accordance with law. My lord, this is, my lord, kindly comes to internal page 2. In the facts and circumstances, both parties of the suit are directed to take steps in accordance of law. There's
No, you are for the plaintiff.
I'm for the plaintiff.
So your advocate submitted that they should be directed to pay occupation charges.
My lord, there are two orders. No,
No, in this order.
No, this is not the order of occupation charges. That fact was brought to
July. So you have submitted. You withdraw. You make a review application.
My lord, kindly sees the application once. I have not.
Maybe
it was a photocopy.
It was your submission.
My lord, kindly sees the application once. Sees the prayer, my lord.
Maybe, but you have submitted.
I have not. My lord, I have occupation. There are two facts.
That, and I will give you leave to file an application there.
My lord, this was not the ground on which the learned judge has recorded this. Kindly takes, my lord, the prayer once. And paragraphs 4 to 7, very short application.
You have complicated this, Mr. Dotto, before the learned trial judge.
No,
this
kindly,
is the order.
my lord, kindly.
Yes.
My lord, paragraphs 4 to 7, the averment, my lord, of the defendant in the application.
Yes.
Defendant has stopped operating from the suit premises on and from September 24th, which is also stated in the written statement. Defendant has shifted its operation from the suit premises. At present, said property is under lock and key. Defendant does not intend to cease occupation. Continuing possession of the suit property is causing permanent loss to the defendant and hardship to the defendant. Defendant now intends to surrender the property and hand over possession of the same. It was only in respect of my lord possession. Prayer. Your petitioner therefore humbly prays that the learned court may be pleased to grant liberty to the defendant to hand over peaceful and vacant possession of the suit premises, and plaintiff be directed to take possession of the suit property on such date and time. My lord, pass an order in terms of this prayer, my lord. Occupation charges is, my lord, on an application filed by the plaintiff which is pending, where I have an order. If there is default, I have my recourse available. That, my lord, has got nothing to do.
You have not said that.
It kindly comes to me. My lord, kindly comes to me.
Yes.
My lord, first page. Yes. Advocate for the defendant submits. Defendant, I'm sure lordship is referring to the next paragraph.
Yes.
Advocate appearing on behalf of the plaintiff submitted. Plaintiff has no objection.
Next paragraph is the relevant.
Kindly, I will come to that.
Seen that.
My lord, I will come to that.
I will come to the next paragraph.
Advocate for the plaintiff also submitted.
Yes.
The defendant did not pay any amount to the or current occupation charges, and advocate prays to direct defendant.
Yes, so this was your prayer.
But this has got this.
I will record your submission that you have not paid this.
No, so I will. My lord, this has got nothing to do with the prayer for possession.
Why did you put that prayer?
Well, the previous order, I just informed the court that the previous order has not been complied with. Court did not say that because it has not been complied.
File an application there, Mr. Dotto.
This will, lordship understands in heart that this will complicate issues unnecessarily. Defendant has complicated. We have not, my lord.
Yes, I will hand over. You have said no. You have.
If I had said no, such time you pay occupation charges, lordship would reject my application. My lord, my submission is not that. My lord, with deepest of respect, kindly allows me to read the paragraph before that. The learned advocate for the plaintiff.
Seen that.
Satisfaction, yes. My lord. Learned advocate appearing on behalf of the plaintiff submitted has no objection if the defendant intends to handle. Besides this, yes. Advocate appearing on behalf of the plaintiff submitted. Said that. So besides this,
yes,
my lord, my first submission is I don't have any.
You are making yes, let them hand over. But
my lord, if this was before your lordship, if this was before your lordship, at that
I do not know what
would have definitely appreciated. My lord, there are
Mr. Dotto, that's a very different thing altogether. What I would have done under such circumstances.
My lord, this is exactly why I am here before your lordship. The learned judge, my lord, saying that, my lord, to take steps in accordance. What does that mean, my lord?
That.
My lord, even then, my lord, what does, my lord, with respect, my lord, to the learned judge, what does this mean? To take steps in accordance with law. When the defendant says, I don't want to contest, I want to hand over. My lord, sending me back would really, my lord, delay things, my lord.
Item number 14.
Now for the petition this matter, my lord. Is a suit of eviction decreed in my favor, my lord. I, my lord, filed the execution application which is pending since 2018. My prayer before your lordship for my lord expedite hearing of my lord the execution application. I have annexed the certified copies. Page my lord 32, if your lordship kindly see the order passed by the my lord trial court. Ordering portion at page 32.
Any miscellaneous case is pending?
No, my lord.
Start
No,
execution case?
no, my lord. All certified copies I have, my lord, annexed, my lord. Up to date certified copies. Last order is 8 April.
What happened on 21st of July?
Well, it has been adjourned, my lord. Simplicity, it has been adjourned.
This application under Article 227 of the Constitution.
Any preferable time may kindly be punishment, sir. 7 years has passed, my lord.
Yes, next.
Lordship, this application for the expeditious disposal of the title suit being number 1350 of 2023, Lordship. Lordship, this
What is the stage of the title suit?
Lordship got the interim order after there is two interlocutory application has pending.
You are the defendant or the plaintiff?
I'm the plaintiff, Lordship. I'm the plaintiff.
What happened to the application under Order 40 Rule 1?
It is pending, Lordship. It is filed
What is the
on
next date fixed for hearing of such application?
6th of November, Lordship.
It's otherwise ready for hearing.
No, Lordship, the opposite party not appeared yet, Lordship.
Not appeared yet.
Not appeared yet, Lordship.
In the suit.
In the suit, but in connection with the application under 39 Order 39 Rule 2A, they appeared. There is the information slip, Lordship. They will accounted
Article 220.
Your Lordship, Mr. Shonak Bhattacharya is arguing for the petition. Mr. Shonak Bhattacharya is arguing for the petition.
Since I'm not inclined to take up this matter and pursue this thing, yes.
But if your Lordship kindly takes up the order impugned hearing, that an application under Order 21, Rule 99, in connection therewith, my lord, and stay application was being moved. The learned executing court, my lord, while dealing with that application, my lord, directed me to pay 1 lakh at a time to the, my lord, decree.
Consolidated or per month?
Kindly see, my lord, the operating portion, 1 lakh in the first, my lord, last operating portion, it is seen the language used is consolidated. But subsequently, the learned judge have made that the payment of one installment, Lord, if I may, Lord, hard and consider, on perusal of the record, it appears that the petitioner has a prima facie case to.
So, Mr. Mukherjee, deposit, show your bona fide by depositing
But I
three
have
installment.
already, without prejudice, I have already paid for 1 month. Already paid.
1 lakh deposited.
That not deposited. This is the direction.
No, paid. You have paid.
Not yet encashed, but Lord, I have complied with without prejudice to my rights and contention, since this is the direction.
That was by draft.
Check.
Check.
I have.
And
but Lord, kindly.
What is your claim in Order 21, Rule 99?
Let me I say, Lord, there was a previous suit initiated, Lord, against the Lord Ghosh and Lord this tenant naam ki? Huh?
You are claiming to be a tenant.
I am claiming to be the tenant of the original owner in respect of the property in question. Admittedly,
there has been transfer.
Yes, that is in transfer to
subsequent transfer.
Ghosh was the original landlord who have let out the property in favor of the present plaintiff. That suit for eviction was there. That eviction decreed. Subsequently, there was a
against the plaintiff.
Against the plaintiff.
Yes.
And in the interagnum, since the eviction proceeding has been initiated by this present plaintiff to a party to whom he claims to have let out the property, subletting. So in the interagnum, this suit for eviction is being decreed. The second suit, the earlier suit already decreed, his right goes. I have claiming the property that Ghosh, the original owner, have transferred subsequently, and the person who have purchased, I am the tenant under him. This is a case made out in the Order 21, Rule 99 to 101. So court finds I have a prima facie case. Apart from that, this is something fallacious, because the law is very well settled. I will have to deposit. Now the direction was consolidated 1 lakh. Subsequent paragraph that it is hereby notified that on non-payment of one installment, the instant stay would be vacated automatically. What for the time being I am asking, kindly clarify that if the learned judge is of the opinion 1 lakh, I will have to, then this has to be deposit, not a payment directly to him.
Because you are a third party.
Yes. Even if I am not a third party, there are certain line of judgment. Order 41, Rule 5 is being explained in the line of Atmaram of the Honorable Supreme Court judgment, and this Honorable Court has held the amount cannot be appropriated. It is subject to result of the appeal. It has to be deposited.
There are two lines. One says payment, another says.
This, if it is arising out of a suit for eviction, if I have suffered a decree and it is a condition for entertaining stay, it cannot be paid.
Atmaram says paid.
Atmaram says otherwise. This Honorable Court in 2016 SCC online, this has
Atmaram says paid. Achal Mishra says deposit.
Paragraph 11. Charge. Paragraph 11. This Honorable Court explaining
Atmaram.
Atmaram is being quoted. Paragraph 10.
Atmaram. Atmaram says deposit.
Deposit. That's why.
No, sorry. Atmaram says payment. Next judgment, Achal Mishra says it will be a charge. Atmaram says deposit. Show me Atmaram.
Kindly see paragraph 10 of this judgment.
Yes.
One of the sufficient ground of stay of execution is an appeal against the decree for eviction is dispossessing during the pendency of the appeal, since the said provision specifically provides that mere filing of an appeal shall not operate such a stay of the execution proceeding. The appellate court may impose condition.
I have 2005 volume 1 SCC 705.
But paragraph 11, quoting Atmaram, this honorable court explained that this has to be deposit.
But now you have paid.
1 month I have paid, but what I clarify, once to I will have to serve and come back. In the interagnum, kindly protect me that if the learned judge, if your lordship is of the opinion, it is not consolidated, it is month by month.
What's the property?
The property. কোথায় রে? হ্যাঁ? 20 Munshi Parallel.
No. That I understand. What is the nature of the property?
Property, it's factory shed. Factory shed.
What's the extent of the factory shed, Mr. Mukherjee?
My occupation.
Yes.
Approximately 3,000 square feet. But I am not on one consolidated. That's why I am taking that plea. If my lord is of the opinion, it is not the intention of the learned executing court to make it a consolidated sum, but it is 1 lakh per month.
So, Mr. Mukherjee, it's better you apply for clarification. I give you that liberty. Because there are two contradictions, I give you liberty to apply for clarification there.
Kindly direct me to sir, and
why? That's the clarification. I think that will be better.
There will be some. The learned executing court is of the opinion, is of the mood that I am not really intent to comply with the direction. But
no, I will record, Mr. Mukherjee, I will record your submission that you have paid.
I have
1 month
for 1 month.
Due to this discrepancy or that confusion, I will give you liberty to apply before the learned trial judge. Before the learned executive
clarify, then only clarify that it cannot be paid. That portion.
I will also record your submission that it is to be. I will also record your submission that
my submission. Your lordship decides that. That's why the learned judge is of the firm opinion. I will have to pay it.
Cite those decisions, Mr. Mukherjee. Do something there. Do something there.
Instead of that, if your lordship directs me to serve, I will comply. Pursuant to my lord's direction, I will comply.
No. I think it's better. Go there. I will record your submission.
It becomes very difficult. Your lordship knows. Once approaching before your lordship court,
I will anything. Mr. I will also record you have relied upon this decision, which says it is to be deposited. I will also quote this judgment and your submission that it's
very well.
This application under Article 227 of the Constitution
I appear for the plaintiff petitioner. My suit for declaration of title and injunction filed on behalf of my client stating the defendant has got no right title interest in the property. My expert, the order of injunction was passed. My we filed an application under Order 39. আপনি আছেন মিলন আপনি দেখুন আমি কি চাইছি বলছে no my lord what happened my lord export the order of injunction against that my lord we filed an appeal in the appeal my lord the appeal is pending since 2024
Miscellaneous appeal.
miscellaneous appeal what I'll be humbly praying my lord you'll also direct deal on a trial just to dispose of appeal because 2 points
Ghosh, do I have any difficulty in taking up this matter?
nothing no difficulty
From Baripur court.
so what my lord thousands of matter in there in Baripur
That is why I'm asking you.
no Well, kindly dispose of them, direct the learner trial just to dispose of my, you'll also kindly seize my application.
So where is the miscellaneous appeal? This is the order of the
Trial code 15th of March 2024, my lord, you'll also kindly seize, that has been challenged, my lord. Is expert
of
2024.
So where is the order of the appellate court?
Appellate court, my lord, the matter is pending, nothing has been touched. My lord, matter is pending, my lord. What I was praying, my lord, kindly direct the learner trial.
What is the number of the miscellaneous appeal?
Yes, my lord, page 45. Base appeal number 18 of 2024.
Service completed in the miscellaneous appeal.
Well, if it is not completed, it will not to be heard. My lord, kindly direct, my lord, what happened, my client, my lord, purchased the property, trying to construct his dwelling house, my lord. No, my lord, by this export order of injunction, it has been stopped. But I was humbly praying, my lord, kindly direct the learner trial to dispose of within a specified time, from 2024.
You have challenged the order of injunction, Mr. Ghosh. Now you are
Now, kindly seize, my lord, 24, I can here and now, guys, say this order is not maintainable. My status quo without
that is a different thing altogether.
That I'm not making out.
Milord, Mr. My senior, Sri Achyut Bosu will appear. Kindly allow time, sir, not today, sir.
I'm not, Mr. Ghosh, though an order of ad interim order of injunction has been challenged, Mr. Ghosh is not pressing that. A miscellaneous, he has preferred a miscellaneous appeal. I am directing the miscellaneous appeal to be disposed of expeditiously. Give the name of your senior. This
I'm praying for my lord in this revisional application, expeditious disposal of the suit. But my lord, there is one application pending under section 7(2) with section 5.
7(2).
With section 5.
Yes.
My lord, suit of 2013, 7(2) filed in 2022 with section 5. My lord, that application is, my lord, stalling the entire thing. My
I
lord,
cannot dismiss it from here, Mr. Chairman.
I know, but my lord, kindly directs, my lord, to expedite
That
the
was
suit
prior
as
to
well.
Devashish Pal. So law,
The
as prior
section
to
5, non-maintainability of section 5 is there long
prior to Devashish
long
Pal.
prior to Devashish.
Prior to Devashish Pal will cover.
My lord, kindly direct the suit to be decided expeditiously. Because
After 7(2) is decided.
my lord,
After 7(2) is decided.
my lord, kindly appreciate, kindly sees the order sheet. It was
After 7(2) is decided.
7(2) decided, but dismissed, recalling is pending. 7(2) dismissed.
No, you are saying section 5 is pending.
Section 7(2) along with section 5 filed.
Yes.
It got dismissed. They filed a recalling.
Recall of that.
Yes.
What is, so recalling application fixed on when?
Well, kindly see the last order. There is no next date, but it was fixed on 11th of September.
That is the petition dated 6th of January
That is
2025.
that petition.
11th of September it speaks. This application under Article 227. Yes.
Please, your lordship. Lordship, this application.
Yes.
Lordship, this revisional application is preferred by the petitioner, praying for expeditious disposal and or early hearing of surface application, Lordship, before the learned Debt Recovery Tribunal 3, Kolkata. Lordship, may I take your lordship to only
the next date? Surface application is otherwise ready for hearing.
Lordship, it's ready for hearing since 2023, Lordship.
All right. What is the next date fixed?
Next date is fixed on Lordship 24th September 2025, Lordship. Lordship, may I please on that day it will be taken up for hearing, Lordship. May I just only show three orders, Lordship. Kindly come to the page 103, Lordship. Lordship, I have preferred this surface application in February 2023. Kindly seize the order, Lordship.
Learned counsel for the applicant filed a put-up application being IA number such and such for hearing of.
What are these IA for?
Lordship, I was preferred for Lordship early hearing of the surface application.
Yes.
Lordship now kindly sees that on the ground that the application has been ousted for paid for early hearing of the essay 142 of 2020 on the ground that the applicant has been ousted from residence by respondent by taking possession. Lordship, nutshell in the fact remained is that Lordship, I have been ousted from my property since January 2023 in a surface proceeding where I am not a borrower, not a guarantor. Some third party has been mortgaged property behind my back, Lordship, and in a fine morning, Lordship, respondent authority with a huge force came to my residence and ousted me. On that very day, I came to know that my property has been mortgaged by any third party to whom I related, Lordship. Since then, it is pending, Lordship. In every year, preparing an application for expeditious hearing before the learned date.
On consent, this date was fixed.
Yes, Lordship. But that day, but kindly sees the date, Lordship, that it's 2nd June 2023 for hearing. That the matter was not taken up for hearing.
12th of June 2025.
Yes, Lordship. 12th June 2023, that the matter was not taken up for hearing. Now, next order, Lordship. I have preferred another application in 2024.
You want me to do now?
Lordship, may kindly direct Lordship that to take my application for hearing, Lordship. At least only that day, 24th September.
This
This is
Yes.
an application, my lord. This is a suit for
declaratory suit for easement right, decreed ex parte in my favor. I am the decree holder. And in the execution case also, they are not appearing. My lord, they kindly come to the bailiff's report in page 53, my lord. I had gone for the execution of the rate, but the bailiff was bailiff.
Where is the execution application? Where is the tabular chart? Where is the tabular statement?
Execution of the writ, my lord. Order of the execution was order 26.
Yes, what order you are challenging?
My lord, order number 27, my lord.
Order number 27, yes.
Yes, my lord, the learned court trial court below did not consider the report of the bailiff and bailiff for the police help and
yes, police help. Where is the order of police help?
My lord, was granted in order number 16, page 49.
Order number 16.
I had deposited the Nazir cost as well as the police cost and
order number 16.
Page 49, my lord. And page 50 onwards, I have deposited the cost of the police and the Nazir, and 16th of June was fixed for execution. And on that day, the Nazir was threatened and he was not allowed to carry out the execution.
What happened on 30th of July 2025? What happened on 30th of July 2025?
I have to take instructions. Just a moment. My lord, as I am instructed, my lord, an order for taking steps were given, my lord.
Yes.
No, my lord, the thing is, kindly come to the bailiff's report, my lord, page 53. I was second last paragraph, my lord. I was compelled to return from the scheduled land and I went to the police station again and submitted a petition applying for next date to execution work. In view of the above circumstances, I pray before your honor to give necessary orders so that I can do the execution work smoothly. So, by not considering the bailiff's report, the decree holder was asked to take steps, my lord. I'm only praying that the police help may be granted by the...
That has been granted.
No, my lord, the court has directed to take steps.
No. That officer in charge has filed a report. What is the report of the police?
Police report is, my lord, next page, page 54.
Page 54.
The bailiff was not allowed to do the execution rate, my lord. So bailiff had prayed for a next date for the police help, my lord. Without considering that...
By the order impugned, the
We beg to appear for the petitioners. My lord,
Yes.
is a appeal.
Yes.
Lord, the petitioner is a landowner. He has sold some plot to the opposite parties. But later on, the opposite party will choose the plot. And
opposite party
will choose the plot and want to refund the money. Refund the money. I want to refund the money. But in the meantime, in absence my filed a suit in the DRT.
DRT.
Consumer. It was ex party. I was not aware. It was put on execution. That I was not aware of. I was not aware. Even in the put on execution. Last occasion is the notice came. But originally when I filed the first petition before the consumer forum, that notice was not come. But later on, when the execution put and police help fought for, that notice came. What I want that apart from all this, I want to refund the money.
Yes.
It is really lordship kindly help people. Then very
For arrest card.
and arrest has been possible.
So you want to comply with the order of the consumer forum?
No. I want to refund the money.
What is the order of the consumer forum?
Refund the money.
Show me that order.
The order number 15.
Page.
ওখানেই আছে
of March 2023. So you are willing to comply with that order?
Order number 15, 19/6/2025.
19/6/2025 you are challenging.
Challenging.
So that is the execution order. Where is the order of the consumer forum?
First order.
This is the order.
This first order. This first
Order
order
was filed on
Filed. President, the order date is 15/2023.
Where is that? Which page?
Yes, the last second page, Lord.
ওখানে পেজ কত এই জিনিসটা যে ফাইল করেছে পেজিশন করেছে
Where is that order? 15th of May.
The last page, Lord, of this order.
Last page.
Last page of this order.
You have not annexed that copy. Yes, 10,90,000. You are willing to comply with that.
I want to comply. So at present, whatever I was not aware of. Even
all right. So I give you liberty. You approach the district commission saying that you want to comply with that. End of the matter.
Opportunity has not given because only the arrest order has been passed. Arrest order has been passed.
That is why I am asking. I am giving you liberty to approach the district commission.
Yes.
Saying that you want to comply with that order. You file an appropriate application.
And in the meantime, actually, stay.
No stay. If you approach, it will be done. No stay, sir. No stay. Till now, you have not complied with. No stay.
We came to.
All right. That is why I am giving you liberty.
Holding that one. I came very later on.
No.
Later on. When the order of arrest passed.
No. When the order of arrest was passed, that was passed on June 2025. So today we are on August.
On that date, I have paid 1,10,000 rupees.
1 lakh is not the order, sir. It's 10,90,000.
10 lakh, but on very date, I give him 1,10,000.
1,10,000.
All right. So approach the
want to compromise.
Approach the commission stating all these facts. Approach the commission stating all these facts. The commission will consider that.
And in the meantime, only one line.
No.
I can't leave that.
This application under Article 227 of the Constitution of India.
Only one line.
I give you liberty to approach the commission. This application under Article 227 of the Constitution of India is at the instance of the opposite party in a complaint case and is directed against an order being number 16 dated 19th of June 2025 passed by the District Consumer Dispute Redressal Commission, Kolkata, Unit 3, within bracket South, in complaint case number EA/68/2023 arising out of CC 96/2021. First of the learned advocate appearing for the petitioner submits that the order dated
19/6/2000
submits that the District Consumer Dispute Redressal Commission passed a judgment dated 15th of March 2023 in complaint case number CC/96/2021, directing the petitioner herein to fund a particular sum of money together with interest. He submits that such an order was passed ex parte. First up, the said order was put into execution, and by the order impugned, an arrest warrant has been issued, and by the order impugned, the arrest warrant, the officer in charge of the local police station was directed to execute the warrant against the petitioner and to file its report. First up, the learned advocate appearing for the petitioner submits that the petitioner is ready and willing to comply with the directions contained in the order dated 15th of March 2023, passed in complaint case number CC/96/2021. First up, in the light of the submissions made by the learned advocate for the petitioner, CO number such and such stands disposed of by giving liberty to the petitioner to approach the District Consumer Dispute Redressal Commission in EA number 68/2023 by making an appropriate application in that regard. First up, if such an application is filed, the learned trial judge, the learned District Consumer Dispute Redressal Commission shall consider the same in accordance with law.
One line, Lord. Only
one line.
Breathing time, Lord. Only breathing time. People lost you.
15 days. Breathing time.
Only breathing time, Lord.
What breathing time?
No, it is an ex parte order without any serving the copy. That is it.
Sir, if you
9 Rule 13 was filed.
Sir, if you want to,
they did not take it.
Sir, if you want to, there are two things. Please hear me. If you want to challenge, you are ready and willing. You are at liberty to challenge. Please challenge that. Now you said
it is not maintainable in this code.
All right.
Section 2D of the Consumer Forum Act.
Take that point. Take all points before the Consumer Forum.
Only 15 days time so that I can afford this particular money to the opposite party.
You approach the commission first. They cannot accept.
Commission is very much rigid, my lord.
In the meantime,
commission is very much rigid, my lord.
In the meantime, to harass, avoid
Nothing,
harassment.
nothing.
Only
Only 15 days.
From 2023, you have not paid.
No,
1 lakh I have already paid.
Only
1 lakh. Sir, order is 10 lakh.
I
1
was
lakh
not
is not
aware.
sufficient.
I was not aware of.
Entire money they did not pay.
Aware of.
As per agreement.
I have given you leave.
As per agreement, entire money they did not pay. 14 lakhs 2025.
If you want to challenge, you please challenge before the state commission. I'm observing that.
I was not in accordance.
That is why. So now when I've given you liberty, you are saying that order is not
to
maintainable.
avoid the harassment. Only 1 lakh to have avoid the harassment, my lord.
Sir, the order was passed long back. You file within 1 week.
Within I shall pass with 1 lakh, only 10 days.
No, not 10 days.
One.
The petitioner lets such application be
Don't know.
Violation-
Next day fixed on 14th August.
No. That is when the next
Kindly.
day of resolution of the bar, or you undertake that even if there is a resolution, you will appear. I will record that.
Kindly direct to our local bar association.
Two things cannot go, Mr. Sarkar, side by side. You want expeditious hearing and you will take adjournment on the ground of bar association resolution. So either abide by the resolution of the bar, don't pray for expeditious hearing. What is the next date fixed?
14th August, my lord.
Police help?
Yes, my lord. My application for police help. My police help. Only.
Where is the order?
My lord, injunction, my lord.
Order 39 Rule 4. Where police help?
No, my lord. My application police help, my lord. Kindly see the order dated for 29th April 2025. My lord.
29th April
2025. Non-step as per resolution local bar. Provision dated at the hearing of petition understanding CPC of police protection. My
Police protection. Where is the application for police protection?
yes, my lord.
Ad interim order or temporary injunction?
Ad interim order.
Ad interim order police help is permissible, Mr. Sarkar.
Temporary.
Show me the order of temporary injunction.
My lord,
If you want to protect through police
my lord, kindly
implementation.
page 21, my lord, order. My lord. Yep.
Ad interim allowed ex parte. It's ad interim, Mr. Sarkar. How do you say temporary?
Oh, my lord.
Order number 2.
Yes, my lord.
So, ad interim,
Yes.
police help can be allowed. I'm disposing of section 151 from here itself.
My lord. They threatened me, my lord. Therefore, my lord, I filed the police help application, my lord.
What is the next date fixed?
14th August.
Ashu, this application under Article 227 of the Constitution None appears for the petition at the time of
The petitioner in this matter.
yes.
25, Your Lordship, I have instruction to appear on behalf of the opposite party.
Yes.
The order under challenge, if your lordship kindly comes to the last page of the certificate copy, it's order number 29 dated 11/7/2025.
Order number 29, yes.
Suit for recovery of possession. I am the defendant. My evidence has been closed for non-payment of costs. Some cost was directed to be paid before, which was not paid, and a waiver application was filed under some
application.
Some advice was there for filing a waiver application that has been rejected.
So what was the cost imposed?
3,000.
How much cost did he incur for moving the recalling application, then coming to this court?
May I just indicate one thing, Lord? Today the matter is fixed in the Learned Trial Court. If your lordship kindly looks at the order of 11/7/2025.
Amount that 3,000 plus together with the cost incurred in the meantime.
I really cannot say anything on this, Lord. I leave it to your lordship. I'll leave it to your lordship. If Lord only kindly consider
The
that.
client can bear this. Litigation cost he can pay.
Well,
But not for.
But I'm ready. I'll put in the cost today. Lord,
Yes.
instructions on
What
this.
you say?
Only Your Lordship kindly sees, Lordship, the conduct. Your Lordship only.
Conduct is very bad. So I'm
Your Lordship, if Your Lordship is allowing them to impose paying the cost, Your Lordship kindly fix a time frame for the DW.
Today. I shall file it today. I
Lordship.
shall send it to the plaintiff today.
No, that if paying the cost
If
will
your lordship
only,
kindly allows, of course. If your
only
lordship kindly
recalls
allows,
the
of course,
order that will allow them to adduce evidence that will open the DW, which has been closed. Now, if your lordship is allowing it, your lordship kindly fix a time frame for the DW.
Yes.
Because then otherwise they will further again keep praying for adjournment. So that is only my.
So today is the fixed date
Today is the date fixed.
Argument.
Argument.
The DW was closed from the last occasion for non-payment of cost.
The evidence of defendant is closed. That is the order today.
And
I'm
it-
sorry. That is the impugned order. Today is fixed for arguments. I'm sorry. Today is fixed for arguments. It was closed on 11, just the last month, 11/7/2025, just 30 days before.
Yes. When this matter will be taken up?
Today is the date fixed, your lordship, 11th of August.
Yes.
Lordship.
Second half. All it's over already.
Argument, I believe second half should be.
Yes. So tender just now. Pay him. Come at 2 p.m. saying that you have paid. I will. Ashun.
Item number 4 for appear for the meeting.
Yes.
This is my affidavit of service. No? They are appearing.
Opposite party, my lord.
Yes. Yes, sir. What do you say? According to him, summons was not served.
My lord, के summons, my lord, na leave not summon lord how to my lord appear, my lord. My lord, these are disclosed. Kindly, my lord, turn page, my lord, 6, paragraph 6, page 5, my.
Paragraph 6.
Page 5, my lord.
Of the civil division application?
Yes, my lord. The petitioner state that on 14/11/2022, the petitioner stroke defendant voluntarily appeared in the said suit by filing Bhokalatnama without being served.
He might have thought that someone might have filed a suit against him.
My lord,
prompted him to appear.
My lord, the voluntarily, my lord,
show me that summons was served, sir.
My lord. My lord, 11. My lord, kindly, my lord, kindly, my lord, order, my lord, substitution of service, my lord, was passed. Order, my lord, 11 May 2022. Kindly, my lord,
Copy of the order.
My lord, order dated, my lord, 11. Order,
Yes.
order. My lord, today each fixed for the case, peruse the case record here. From it appear that plaintiff के file one petition supported by affidavit stating that the summons sent to the defendant has been returned with the mark not claimed. My lord, this is the my lord but not claimed. My lord, on that day, my lord, substitution of the service, my lord, the application was made and the was allowed. Kindly, my lord, I want to draw, my lord, some dates. Kindly, my lord, this is the. My lord, 11, my lord, this is the dates, my lord, 11 January 2019. The summon was duly served upon the defendant by hanging. Even the registered post return on unclaimed, the defendant did not appear. मतलब कि 11 May 2022 the learned advocate below court below passed an order of substitution of service someone upon the defendant by an advertisement in Bengali widely circulating in the localities in which the defendant is largely known to have actually and voluntarily residing or carrying on business or personally working for gain. And 13 August 2022, the paper was published.
You have brought the original. I have asked you to bring the photocopy of this order sheet.
No, I have the photocopy as well.
Please give me the photocopy. Take this because otherwise,
my lord may. Very well.
It may be for
This
other. Oh, you have marked there.
Yes.
In I asked you to bring the.
No, I have the photocopy. I shall replace it after the final.
My lord, date of receipt.
Give me a minute. Give me a minute.
नामটা লিখে দিয়ে দে না ফোন নাম্বার পেয়ে রাখ না রাখ
Yes. Yes.
This is the paragraph 6 no date when someone how to receive the summon. And kindly
Or how he came to know, when he came to know.
nothing not disclosed kindly turn page the 7-1 petition, the page 19 and 2 petition page number 22. Second paragraph. The petitioner stock dependent has appeared in the instant suit by filing and your petitioner is ready and willing to contest them. Non disclosing the date. Date is the very important the summons date. Non disclosing it is the considered to be the suppression. That the threshold liable to be dismissed. Nowhere in the petition, neither civil division petition, but before your lordship, kindly note 7-1-7-2, no spreading the someone was received. This is the important the date.
May
And
Consistency একটা একটু দিন তো।
clause B.
Yes.
My lord, kindly, my lord, order, my lord, which is challenge, my lord, order, order, my lord, 30, my lord, dated 26.
Order?
30, order number 30, my lord, dated imprint.
Yes.
My lord, ordering portion, my lord, hard both side, my lord, bottom. Peruse the petition that challenge and the case record. On peruse on of the record, it appeared that defendant appeared in the suit on 14/11/2022 and filed the petition under section 7-1 and 7-2 on 7 December 2022. From the report of the court belief keep to the record, it appeared that the summons was duly served upon the defendant on 11 January 2019 by hanging. Even the registered post returned as unclaimed. Even after that, the defendant did not appear and by way of substitute service publication was made in local newspaper by order dated 12 August 20.
Where is this order holding that the service returned with the endorsement unclaimed? By which order?
My lord, this is the my lord, this is the kindly my lord. Did I have my lord, my lord, my lord, this is my lord, 22, my lord, order number 11, my lord, I have my lord.
Order number?
11, my lord. Order number 11, dated 11 May 2022.
Yes.
My lord, peruse the case record where from it appeared that plaintiff filed one petition supported by affidavit stating that the summons sent to the defendant has been returned with the remark not claimed.
and hence the petitioner is paying for substitute service under the provision of Order 5 Rule 20 of CPC. Peruse the record and petition was under consideration, considered, therefore under the above premises the court of the opinion that petition under Order 5 Rule 20 of the CPC shall be allowed. Unclaimed, my lord, is also the good service, my lord.
Yes.
And my lord, no, neither my lord, civil litigation petition, nor my lord, any of the 7 8, when the how to know, source of know, nothing that not disclose, non-disclosing the date, my lord, itself the suppress of the material facts, my lord, which is liable to be but dismissed. My lord, submission.
Yes, what do you say in reply?
The court records in the order allowing Order 5 Rule 20, this court is of the opinion that the petition under Order 5 Rule 20 should be allowed. The court does not record its satisfaction with regard to service of summons. If the service of the section 7.2 is very clear, either service of summons or where I voluntarily appear in the suit, 1 month from either of the two. And the court, in the entire order sheet, the court never records that the summons was served upon the defendants and there was a good service. The court, after those summons were served or unserved, that the court allowed an application under Order 5 Rule 20 for alternative service. That could not have been, the court could not have come into, did not come into a conclusion that the summons were served upon me. I only pray that the summons
This application under Article 227 of the Constitution of India is
can photocopy and replace it.
You said you have got
No, no, my lord,
photocopies.
may keep it. My lord was inquiring, that's why. My lord may keep it. Very good.
I've said that I've kept it on record. That is why I wanted only.
Very good.
ওটা বলুন। That certified copy is taken on. That is why I asked you give me the photocopy. You have said you have marked it.
Both of them were marked. That's I'm grateful, my lord.
Allowed. CO number such and such stands allowed. With the above observations and yes. Call the next matter.
Matter number 8.
Yes. Yes.
My lord, petitioner or my lord, the defendant in a suit, my lord, for declaration and injunction. In a suit for declaration and injunction, my lord, declaration in respect of my lord, I am my lord defendant.
Yes.
My lord, declaration in respect of the adverse positional right over the suit premises. My lord, Order 39, Rule 1 and 2 application was preferred by the.
You are the defendant.
I'm the defendant.
Suit for declaration of adverse possession.
Suit for declaration of the adverse position.
Where is the plaint?
Plaint has been annexed, my lord. Plaint is, my lord, page 14 onwards, my lord. Page 14 onwards, my lord. That is the
perfected by adverse position and for permanent injunction. Yes.
Permanent injunction. Order 39, Rule 1 and 2 application was preferred, my lord. The learned court below, my lord, refused the ad interim order of injunction. That is, my lord, appearing in page 25.
Yes.
Page, my lord, 25.
Yes.
Challenging the said order, my lord, plaintiff, my lord, preferred and miscellaneous appeal, my lord. And, my lord, the learned appellate court, my lord, allowed the ad interim order of injunction in the nature of the status quo.
Appellate court orders the contested order? The order.
No, my lord, contested order.
Contested order, yes.
Contested order. Now, my lord, here the learned court below refused the ad interim order of injunction on the ground that not a single document which can substantiate the continuous possession over the property for a period of 12 years or more has been produced by the plaintiff. Now, my lord, the appellate court, my lord, without going into the findings, no reason order, my lord, that what is the document which can substantiate that the continuous possession, plaintiff or continuous possession over the property, that passed and this order, my lord, is the nature of the status quo. Now, my lord, in the meantime, that property, which is the, my lord, suit property, that has been transferred by the
document you have produced to show your possession.
No, that property, that I am the defendant, my lord. Here,
yes.
That property has already been transferred.
Before the appellate court, it was a contested, you said. That is why I asked you.
It is the contested.
What document did you produce before the appellate court?
That property has already been transferred to the third party. That third party in possession, this
you are not in possession.
I'm not in possession.
So how are you aggrieved?
My lord, the difficulties is, my lord, that that third party, my lord, filed an application under order 39.
Third party come and
order of injunction has been granted, my lord. That is appearing in page 26, my lord. Page 26, that order of injunction has been granted. Not a, my lord, single documents, my lord.
Page 26.
Page 26. Page 26, my lord, injunction has been granted restraining the, my lord, this plaintiff, my lord. Restraining this plaintiff to interfere into the possession of the scheduled property, suit property.
Was this relied on before the court bill? This was not relied on before the learned court bill. This was not relied on before.
My lord, that has been stated in the written objection itself. My lord, that is the documents that the third party preferred an application under order 39, rule 1 and 2, and this application, this injunction was granted by the same court, my lord, in respect of the same suit property. Now, my lord, here,
yes.
Here,
so if this order is there, how
things were not relied on?
Maybe now he has produced this.
What is
there will be contradictory orders. One order, yes.
Yes, my lord.
What can be done?
May I say, my lord?
Not a single piece of paper that can substantiate.
Several documents have been annexed, my lord, including the record of rights and all, to show that I'm in possession, my lord. Relying on those, my lord, the court has passed this order, my lord.
But subsequent this order that is ad interim, subsequently the trial court has again injuncted you.
But that was in the meantime, during the pendency of the appeal.
But prior to the appellate court passing that order.
Yes, during the pendency of the appeal.
So this order has not been challenged. This order still remains binding upon you.
I will have to see, my lord, who were the parties and all, my lord. This was not relied on.
No, this is a different suit.
Yes, this is a different suit.
It's a different suit, my lord, preferred by the third party, my lord, because I have transferred, my lord, the title. This suit property title has been transferred.
So let that, that third party canvas. So,
my lord, to
I was thinking that in that
No,
suit
no,
he
no,
has
my
been
lord, to
arraigned.
substantiate the continuous possession, some document has to be produced, my lord. Not a single document, neither, my lord.
Sir, you have transferred. You have transferred. Let the third party now come. He has not challenged this. He has not challenged this.
My lord, this order is binding upon me.
And
This appellate court order is
the
binding.
appellate court has taken note of a record of rights which stands in their name.
No, no, my lord, not recording. Jobor Dokolkari. That means my lord, force to
Yes,
occupy.
adverse
That
possession.
that
So
is my lord in the ROR, my lord.
he is in possession. That shows he is in possession.
He is not possession, my lord. Not a single
Yes,
document.
yes.
Except this record, there is no such document, my lord. The electricity bill, not even
This application
nothing,
under
my lord.
Article You will not be third party, you are not disposed of.
The injunction order has been vacated. Lordship kindly come to.
Injunction order?
The injunction order, that the injunction order has been granted and made final.
Yes.
Upon hearing both parties.
Has been made final means injunction order is there.
Injunction order is there. In violation of the injunction order, this has been done. This is that case. And order 39 rule 2A is. Now, my lord, your lordship kindly come to the plaint.
Then Mr. Banerjee, you have to serve because ex parte cannot be done.
No, ex parte cannot be done.
There is no caveat.
Undoubtedly, there is no caveat. Only thing, my lord, then in that case, my lord, stay the further proceeding of the suit.
Why?
Because, my lord, the suit has been fixed for peremptory hearing. I have
let the suit proceed.
No, my lord, my institutional application will be rendered infructuous.
Mr. Banerjee, suit, there is with this suit. Maybe your suit, this cannot have any impact on the suit. Let the suit proceed. Why do
the whole question is this will be infructuous?
No. Nothing will be.
Lord, then this will be
what is the decree sought for in the suit?
Yes, Lord, decree, because in that case, your lordship kindly come to the decree that was not for restoration, because at that time it was.
That is a different thing altogether.
16, kindly come to page 16.
Yes.
That is the plain paragraph.
That is the declaration of your easement right.
Easement right.
So let it be decided. Nothing will happen.
Easement right and permanent injunction.
Yes.
Your permanent injunction.
So injunction is there. Temporary injunction is there in your favor.
Temporary injunction. Lord, question is, my lord, that in view of the Supreme Court judgment, it has to be restored.
That is, my
lord, Lord, suit will be rendered infructuous.
No, suit cannot be rendered infructuous.
In the event, my lord, suit is then this will be rendered infructuous. Application will be rendered infructuous.
No, in the suit, Mr. Banerjee,
your lordship, so that they may come.
Mr. I will direct the hearing of this application. The suit should not be stayed.
Then, my lord, for order, so that I can sub copy to them.
This. This is put. Yes, call the next person.
I am for the petition.
Yes.
The defendant is the petition of your lordship in a suit for recovery of possession. What happened, my lord? An amendment is been allowed at the stage when evidence is closed, argument has been started, and the court it is the opinion of the court on the order, my lord, this last see on perusal of the record. It transpired that the amendment sought for by the plaintiff while within the knowledge before filing of the suit, though there is a reasonable delay in filing of the amendment. This is the proviso of 17.
What is the suit for?
Suit for declaration of possession, declaration of possession. I have annexed the amended plaint. The amended was made, my lord, earlier also, and that amendment allowed. Again, amendment has been sought for. Page 8. Evidence of the.
What is the amendment sought for? Please show me that.
Your lordship kindly come, but just a minute. Page 19, 17, 18, 19, say 16 to 19. Oh, sorry, madam. Sorry, madam, just a minute. Ma'am.
No, that is the written statement. Where is the application for amendment?
Just a minute.
Application for amendment, is it at page 35?
Just a minute, madam. Before the order.
Yes, the amendment is formal.
Formal, but my lord, these, I mean, the exam, they already, my lord, the commissioner has submitted his report.
What report commissioner has submitted?
Here, your lordship kindly understand.
Where is the commissioner's report? Show me.
That I mean, course, madam. Page, my lord, 20, PW1, petitioner evidence closed. Argument started.
No.
I have given, I'm telling you, just a minute.
What is the commissioner's report?
Page 27.
Yes, two-storied.
Advocate commissioner.
Yes, two-storied building.
Yes.
Yes, and that is the amendment. So what is the difficulty?
But then why amendment is required?
Formal, nothing.
At the stage court has admitted, at the stage when the
Number 7.
Yes.
But in this matter, your lordship asked me to submit that judgment. That judgment I will get on tomorrow, my lord. My lord, I am submitting certain things which I have extracted from the online. Your lordship will find from this that commercial court, civil court.
Sir, not in this way. If you want to submit decisions,
My lord, I will
write
eventually
decisions.
submit decision tomorrow.
After some argument, the
Paying for deposit of admitted arrears by installment.
admitted arrears by installments.
My lord,
Unheard of.
My lord, he has also filed, my lord, placed the challan. My lord, the court rejected such application without allowing me, my lord, to deposit the rent, my lord, at a time. Therefore, my lord, I pray, my lord, that the court within the time, my lord, fixed, I filed application under section 7(1). And along with a challan, my lord, for deposit of the entire rent.
No, I could not follow. When the summons was served?
On 19th May 2000.
29th May.
19th May.
19th May
2025.
2025 summons served.
Appeared on 5th June 2025. On the date, my lord, he filed application admitting area for allowing him to deposit such rent, but prayer was made for installment. The court fixed the application on 30th June. On 30th June, my lord, the court rejected the application holding that installment prayer is not maintainable. But my lord, my prayer is also to deposit the entire area. My lord, the court, instead of rejecting, my lord, ought to have directed me to deposit. And my lord, challan was placed for area rent along with interest, my lord, that alone.
Challan was also placed.
Challan was also placed with regard to entire area.
Where is the 7(2) application? What is the dispute?
The dispute with regard to area rent, as also, my lord, the application, my lord, that is annexed A to the application. In that
So this 38,022 is the total, including. You have created these complications.
My lord, no doubt some complication was here. My lord, I can hurt.
This 13th June, that application was rejected by the impugned order.
By the 30th June, by the application was. And my lord, the challan has also not been passed. I have not been able to.
So 13th June, that order was passed on 30th of June.
30th, yes.
Yes. Service. What is it? Yes, next.
Item number 26.
For the petitioner. Lord, suit for declaration and injunction in respect of common passage and garage in respect of the property in question. Lord, what happened?
Common passage.
Common passage and garage. So
What is the impugned order?
Lord?
What is the impugned order?
Impugned order, Lord, the learned appeal, Lord, suit has been dismissed.
Suit dismissed
by the learned trial court on the ground that the property was initially gifted to the predecessor in the interest of the parties by Refugee and Rehabilitation Department, 4 kathas of land. Lord, in 1989. In 1997, the said Dhoni, Lord, makes a settlement that his youngest daughter, he will live, he was living with him, he provided money for construction, and upon his death, that 1 katha, 27, 9 square feet, 9 chitaks and 27 square feet land with garage will go to it together with the right of common passage, because he will enjoy. And even during lifetime, if there is any scarcity, he can sell the property. This was the transfer. He died in 2000, original Dhoni. Thereafter, the daughter, he by deed of conveyance transferred the property to my client in 2006. I have been enjoying, there was no dispute. So far the property and common passage is concerned. Subsequently, the other co-sharers, they have transferred. Now, the transferee from them, he is interfering with the garage and common passage. That's why the suit was filed. The learned trial criminal all through from the filing of the suit till disposal of the suit, injunction was there because my possession has not been disputed by anybody till today. Now, the appellate court, Lord, he has refused to pass any order of injunction. Against that we have come, kindly by the impugned order.
Where is the order of injunction passed by the learned trial judge contested?
Lord, that is, Lord, order passed on identity order, page 45, 46, 45, 46, 47.
So 45,
Lord, part 1
is the identity.
Yes. And next page, Lord.
Next page is the temporary.
Temporary.
47.
Till disposal, Lord.
No, 48, 45.
Lord, it is, yes, page 47. It is further directed that the identity order of injunction will be extended till disposal of the suit. Last line of page 47.
Last line of page
47.
47.
Yes.
Oh. Extended till the disposal of the suit.
Yes.
And what was the identity order?
Lord, identity order that
page 46.
46. Yes. The prayer for the plaintiff for obtaining an identity order of injunction is hereby considered and allowed at this stage. Both the parties of the suit are directed to maintain status quo in respect of the nature, character, and possession of the Schedule A and B property.
Yes.
Lord, this was there.
Now this suit was dismissed.
And that is on the ground, Lord, this Nirupan Patra was executed in 97. That is within the 10 years locking period. That is the only ground.
Yes.
Lord,
now the appellate court has rejected your prayer for injunction.
Yes.
Where is that?
Lord, that is not the impugned order.
Second volume.
Lord, second volume, Lord, kindly take. Last annexure.
Yes.
And my lord, so far the garage is concerned, mentioned in the deed, Nirupan Patto garage is mentioned. In my deed, not the area has been matching. So far their transfer deed also, initial deed, there was no garage. But subsequently they have included garage and area has been matching. Therefore, my lord, there is no difficulty if it is investigate.
So the interim injunction has been refused.
Yes.
Temporary injunction, have you entered appearance?
Yes.
What is the
On
date of it?
KVA, on KVA, no, it has been.
No. In the appeal.
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 Appeal, they contested it.
No.
Written objection, yes.
Yes, written objection has been filed and my lord,
But it says that the issue notice upon the respondent numbers 3 through 7 asking them to show cause.
3 to 7 are non-appearing respondents. Now, my lord, if my learned friend has finished, my lord, I'll draw your lordship.
Have you filed your written objection?
Yes, we have filed because I am
They
actually
only contesting party.
You are the only contesting party.
Yes. Now, my lord, kindly, if my learned friend has finished,
yes,
kindly have a look at the plaint. My lord, let us see, my lord, what is the scope in the plaint. My lord, show specific averments, 2 paragraphs, my lord. My lord, with regard to possession, my lord, he asserts that he is in possession. So, my lord, there has to be a positive statement in the plaint. Now, my lord, kindly have a look at paragraphs number 16 and 17, my lord.
Yes.
It is pertinent to mention herein that the defendant number 3 tried to make constructions over the common passage and or in the suit property, thereby encroaching the common passage. So, my lord, he admits that I have already encroached. It is not something that he's saying that I have dispossessed him. He admits that I am in possession, which belongs to the parties to the suit commonly, and tried to cause digging of the soil of the common passage for erection of the wall, thereby encroaching the entire portion of the property most illegally and forcefully. Now, my lord, kindly also sees next paragraph 17. However, in the meantime, the defendant number 3 illegally and wrongfully convinced the defendant number 1 and 2 and sold out 2 katas, 6 chotas, 18 square feet of land by including common passage measuring such and such feet and the plaintiff's garage measuring such and such feet instead of 1 kata, 2 chotas, 36 feet. So, my lord, there is a clear dispute with regard to title. Now,
so there is a dispute with regard to the title.
Now, how
so
does
now the appeal is pending?
Now, my lord, kindly
that has to be
appreciate-
adjudicated.
Yes, my lord, now kindly appreciates how does the title flow on the principle of nemo dat non cord habet. My lord, if a person does not have a title to transfer, my lord, can he transfer? Today, prima facie, my lord, the state, my lord, in a deed of settlement, whatever it might write, but he has to seek a confirmation from the state because state is the landlord. So, my lord, I cannot just on my whims and caprice transfer a portion of the land to one of my daughters within the lock-in period and say that that settlement to be valid. Because otherwise, what happens if it goes
But
by?
that is to be decided in the appeal. Then what remains in the appeal to be decided?
If your lordship intervenes and grants him an order of injunction, today, my lord, the entire
The order of injunction was still the
now, yes,
still the dismissal of the suit.
I'll show that, my lord.
Yes.
There was no contest in the injunction application.
That is up to you. You did not challenge that also. You have contested, that is for you. You have chosen not to contest.
This is the situation, my lord. Today, rightly, wrongly, my lord, this is the scope of the appeal. A decree has been passed in my favor saying that he does not have a right. He does not have a right in respect of that portion because he has failed to, my lord, obtain any decree in his favor or a declaration in his favor. Today, my lord, the dispute is today he says that either the deed of settlement will stand or, my lord, the deed of gift subsequently by which, my lord, my transfer.
Where is the decree passed in the suit?
My lord, yes, I'll draw your lordship's attention, my lord. Kindly takes up page number
Page 94.
194 onwards.
194.
Yes, and my lord, I'll show the issues which were framed and, my lord, how they were adjudicated. What evidence came in. Kindly, your lordship will first take up page 196. And, my lord, the pertinent issues would be issue number 3 and issue number 4. Whether the plaintiff has any right title interest over the B schedule property, whether A schedule property is a common passage. So, this is the gamut of the entire dispute. Now, my lord, apropos this, my lord, kindly comes to issue number 3. kindly comes to page 198, my lord, the relevant portion. The learned court has taken into consideration. The government of West Bengal, has your lordship found it? Page 198.
Page 198.
198. My lord, this is my lord, relevant for adjudication.
Yes.
I'm not placing the entirety. The government of West Bengal.
Which portion? Which
my lord,
portion?
page 198, first paragraph, last 4 lines I'm placing.
Yes, yes.
The government of West Bengal executed such deed of conveyance, Exhibit A, in favor of Vidubhushan Bhomik, who happens to be a petitioner in interest of the plaintiff's vendor, as well as the defendant number 327. The recitals in page number 2 of Exhibit A run as follows. The donee shall and may at all times thereafter peacefully and quietfully possess and enjoy the said land hereby given, granted, and transferred, subject to the condition that the donee shall have the right to save as hereinafter provided to alienate or transfer in any way the land comprised in schedule hereunder, written in any manner whatsoever within a period of 10 years from the date of the presence, without obtaining prior written person of the donor. So, the donor here is the state. So, if a transaction at the very instant, if it is void ab initio, because admittedly 1987, in his plain case, I'll show he was transferred within 8 years. And the court has taken cognizance of that. Now, my lord, moving forward, therefore, the last paragraph I'm placing, therefore, it is vividly clear that there was a restriction imposed on Vidubhushan Maulik to transfer, alienate the suit land for 10 years, except the above mentioned authorities. During the course of the argument, it was stated that Nirupan Patra or Exhibit 3 was executed in favor of his daughter, only, who was also a family member and not to any third party. However, avoiding the repetition, I am to point out again that Exhibit A clearly speaks about the relevant authorities in favor of whom Vidubhushan Bhomik could create type of interest, and execution of Nirupam Patra in favor of his daughter Baby Roy does not come under those exceptions. Therefore, this argument is not tenable. Another point was also raised that the language of Nirupam Patra clearly suggests that it is a conditional gift effective at the death of Vidubhushan Bhomik, and admitted he died after the expiry of the lock-in period of 10 years. To adjudicate the issue, let us go through the definition of Transfer of Property Act, such and such. My lord, now Transfer of Property Act is quoted. Now, my lord, kindly takes for schedule mentioned property, that is a suit property, will pass to Baby Roy in the event of death of Vidubhushan Bhomik. In this case, Exhibit 3 was executed in the year 1997, which means that by transfer of the suit property, the interest was created in favor of Baby Roy. However, the interest was to take effect on the death of Vidubhushan Bhomik. The settler Vidubhushan Bhomik was bound by that settlement deed and could not be revoked or cancelled except in accordance with law. Even though the settlement deed came into effect after the expiry of 10 years, yet the interest was created before the expiry of the stipulated period, thereby violating the terms and conditions mentioned therein. Consequently, Exhibit 3 does not stand good in the eyes of law, and Baby Roy cannot acquire any right, title, and interest over the suit property by virtue of the deed. Provisions of Section 8 of the TP Act is quoted. Thereafter, in the case in hand, as Baby Roy did not have any right over the suit property, she was not capable of passing the same to the plaintiff, by virtue of which the plaintiff claims her right over the Schedule A and Schedule B property is also not acceptable in the eyes of law. So, this issue has been completely decided, taking into consideration the deed of settlement. A person who does not have a right under the law to transfer cannot, after a decree, file an injunction application saying that I am in possession. Nowhere in the plain it comes that he is absolute in possession and he is in unfeathered possession. Yes, I'll show.
Paragraph 4 of the plain.
Yes, yes.
Specifically. Yes, 2006.
No, he says unfeathered right over the common passages.
That's all.
But he seeks declaration in respect of
both. Enjoying both premises, both the premises, unfettered right.
This application under Article 227 of the Constitution. injunction is pending, then you say so I can make that injunction order and absolute and I can
He
direct
will never endeavor to my lord, get the title appeal heard till he is enjoying the injunction.
unless the injunction is heard, it cannot be done.
Because this is the scope.
Toyota disposed of. Yes, next.
Item number 27.
Yes.
Your Lordship was pleased to hear this matter on the last occasion. I was unable to complete my
Weekend intervened, long weekend intervened, Mr. Chatterjee.
I'm sure my lord hasn't forgotten, for sure.
Opposite party number 1 and 2.
Opposite party number 1 and 2. Mr. Sen, you are for? There is a dispute. Who is your client?
Well, it seems well, he is my advocate on record. Shajol Das is, I am appearing on behalf of Shajol Das.
Shajol Das is which opposite party? Shajol Das is opposite party number 1.
না না আপনার বোধহয় মামলাটা অন্য মামলাটা অন্য
Matter, my lord. It's a different matter.
মামলাটা
Yes.
Lord, initially, my lord, I had placed before your lordship.
Who are you?
Lord, I am the plaintiff in a suit for declaration or rather cancellation of a document, and also, my lord, that the passage is a private passage.
Again a passage. Again a passage.
Again a passage.
Yes.
Is a private passage.
So according to you, it's a private passage. You are the owner of that passage.
According to them, in their written statement, they have said that that passage, there is today, the problem is with respect to the passage. There are disputes with respect to other plots of 36 and 37. That I'm not troubling your lordship because that is not the subject matter of the Order 26 Rule 9 application. Now, what happens is, my lord, I have a case of encroachment. Now, this encroachment is not an encroachment, my lord, where they have come up to my passage and, my lord, they've constructed. No. What they've done is, if this is their wall, they have constructed a gate there and they have started, my lord, using my passage. This is that encroachment, my lord. This is not about constructing and coming into my passage and then, my lord, no, that's not. Why this Order 26 Rule 9 was filed was because of the court.
Because of the
court. The court required it. Why I say that, my learned senior friend is a little surprised. I'll show you a lot.
I'm also surprised.
Yes. Can you turn to page 85?
Not your senior friend. I'm also very.
Kindly have a look at page 85. We are now, my lord, at the injunction stage. Turns to the last paragraph. I'm sorry, my lord, last paragraph. While appreciating last but 4 lines, my lord.
85.
85.
This is an order of injunction.
At interim order of injunction refused.
Yes.
Looks to, my lord, the last line. While appreciating all aspect, my lord, Kali got it.
While appreciating
all aspect and considering the respectful submission of the learned counsel for the plaintiff, the matter of acquisition of the property in question, although have been clearly reflected in the documents provided, but yet without going through the intricacies of evidence of the matter in issue, this court is not inclined to pass any order. More so, this is important, it is also important to have the suit property locally inspected to see the actual state of affairs of the dispute in order to determine the actual matter of dispute. Now, this was the order passed, my lord, by the learned trial judge. When this order was passed, my lord, after this order was passed, we came up before this honorable court. This honorable court, my lord, did not set aside, but granted, my lord, an order of injunction. And there is a status quo, my lord, which is there. So once this order was passed, we thought it best, my lord, to put everything on record, my lord, before the trial judge, because this is the finding of the trial judge.
Show me your plaint.
Yes. Kindly turns to, my lord, it's a longish plaint.
Please take me to the prayers.
Yes. Kindly turns to page 48. I'm sorry, the relevant portion would be 48, blood starts from 47, the prayer portion.
Yes, 48 is the relevant.
Yes, blood. Kindly have a look at paragraph prayer 3. a degree for declaration that the plaintiff is the co-owner along with all the rights over the passage as described in Schedule B herein below duly identified and delineated for the egress and ingress of the Schedule A property. And the said private passage is also meant for the common user of pro forma defendants 3 to 6.
You are claiming this right by virtue of a document.
Of a document. And they are also claiming a right, not by virtue of a document. We have prayed for relaying.
Mr. Chatterjee,
has
both the
not
documents,
rejected it.
no, both the documents,
I understand.
both the documents will go to show the right of the respective parties with regard to the passage and with regard to the existence or non-existence of the passage.
I was emboldened, my lord, or rather I was forced to file this application because of the observation of the court. Now, court, my lord, has not rejected my application. I am not saying, my lord, that the court has rejected. That is something which I am not too sure about.
Strategy, because
now, what
prima
happens
facie,
is,
if that is so, let it be, let it remain till now. Your right has not been closed.
No.
So let that, because the
No,
court,
I was wondering,
felt that it is necessary.
I was wondering. It's not, my lord, it's not a submission on with a lot of
According to
conviction.
you may argue that the code, the civil procedure code, does not fix any stage at which the application.
At the stage of injunction, there is no dispute.
So
this application is filed
at any stage it can be filed. I am not on that.
But the
Considering the nature of the dispute,
my
Mr.
respected
Chatterjee,
submission is that if either court allows it or rejects it, there is no provision on earth which says that I keep it in abeyance whenever I want it, I'll bring it out of the fridge and I'll have it. This is not something, Lord, which is contemplated
I'm
by
directing the local investigation to be heard out and disposed of.
Very good.
Mr. Chen, there is no difficulty.
Local investigation to be
heard out and disposed of. He says could not have been kept in abeyance. Let it be decided. What is the difficulty? He says it could not have been kept in abeyance. Now, since I filed, it has to be decided now. Because there is no stage.
Malad, kindly consider the schedule of the inspection.
Mr. Shane, if, that is why Mr. Chatterjee has stopped at that. Because, but the difficulty is, if an opinion has been expressed, I could have gone into that. The learned trial judge has kept it at that.
After expressing an opinion, learned trial judge has said, Malad, the documents are not before the court, Malad, and the way the Malad.
Very good. I agree with my learned senior friend Millard, but when the document comes up, if the learned judge feels it's necessary,
that is why both of you will be at liberty to press that application. I am preserving that liberty.
Very good.
This application under there, going there. I'm not meaning you.
Regularly in that building.
May not be you as an advocate, maybe someone else who will represent your client.
That is our bread and butter, my lord. That's how we survive.
No, that is why I've said, maybe you may be saying that I am not representing, appearing in that court. That is why I've said,
Your my lord, I'm representing my client wherever it is.
yes, call the next matter.
So grateful.
Disposed of. CO disposed of. With the above observations, CO disposed of.
I'm obliged.
RC item 1263 with 1264. So in this matter, I am appearing for the petitioner in one of the revisional application. Mr. Mukherjee was appearing for the other.
Madam, it's difficult. Please start. Otherwise, every day it cannot be adjourned or it is to go down. Or it is to go down.
Then I will be prejudiced.
So this is the third day on
But
which
the
it
issue
is
is
being
with
adjourned.
respect to my lord, the quantum of my lord, the alimony penalty like my lord, granted by the trial court.
You are the
My revision, I'm for the husband.
For the wife, I have filed the first revisional application
For enhancement.
for enhancement.
Yes.
And I say, my lord, the manner in which it has been calculated is.
I think the order is to be affirmed.
But perhaps
best
after
thing.
going through the order, your lordship would not find that.
Yes.
The calculation has been made, my lord, she will make her submission in gist, my lord. The calculation has been made today. If I'm earning 80,000 and she is entitled to 30,000, so my lord,
So you want decrease.
the revised calculation will solve my purpose.
No, you want that the
Is decrease. One is decrease. The other
she
one.
wants enhancement.
Yes.
Yes, if you can move your application fast. Because if enhancement is not permissible, then whether it is to be diminished has to be considered.
Even if enhancement is permissible, then also the recalculation has to be.
That I will consider.
My lord,
Yes, yes. Which is your application?
That is the first revisional application. That is
Your number?
your number, my lord.
3292.
Yes, my lord. 3292, my lord.
এই দুটো ফাইল দিন দুটো yes 3292 yes
292 is my application, my lord. In this application, my lord, my case is that, my lord, the court, the learned court below not considered the affidavit in asset which is filed by the husband in the said affidavit in asset, my lord.
What is the husband doing? What is the alimony which has been granted?
80,000. Presently, he has given 30,000. He has not given the enhanced amount filed by the awarded by the learned trial court.
80,000
Yes, my lord.
from the date of
Filing
of the application. What is your husband doing?
He is the businessman, but he mentioned in the affidavit in asset, my lord, he.
What is the finding of the learned trial judge with regard to the income? Please show me that.
In the trial court, my lord, in the internal page 10, my lord.
Yes.
The internal page 10, my lord, the last paragraph. That is the mention from the documents and the averment on record. It reveals that the either side had made effort to establish the financial solvency of the advisory. If we proceed from the admitted facts and respective parties, it transpired the OP is a director of 14 companies, out of which 5 companies provided his salary, rupees 38 lakh 55,000 per annum. He is also having other income of rupees 11,000. 11 lakhs 92,892 per annum for other sources. Thus, from the self-declaration of the OP, he is having annual income of such and such minus. Monthly, he has claimed that he has taken a loan of rupees 1.40 crore, which he has mentioned that he has taken a loan for his business, but he mentioned in the affidavit in asset, my lord, that he is a salaried person. Is the first anomaly which we have. It is my case is that he has not the salaried person. He is a businessman, but the court hold that he is a salaried person. And from the court considered the IT returns of the petitioner, IT returns, my lord, but in the affidavit in asset in the bank account,
You are also a director of a company.
I am. No. I am not the.
She disclosed she is the director and 5% shareholder in a company which have incurred loss. Internal page 11.
Yes, my lord, I have that.
Effective second paragraph.
Disclosed. She disclosed that she has directed and 5% shareholder in a company
Yes.
which have incurred.
So you are also a director in a company.
Yes, he had filed IT. I have filed all my documents, my lord. Considering that, statement IT does reflect there is a in the OP and PD. The court had not considered the actual income of the husband, my lord. That is my case. Considering without considering the actual amount, my lord, the court granted the amount. Affidavit in asset, my lord, they have in their affidavit, their revision, my lord, they have disclosed the asset but without any annexure. This is the affidavit in asset of the husband, my lord. আপনি 10 মিনিট জিজ্ঞেস করবেন আমাকে বললো 3 দিন কি জজ বলছে ইয়ে করছি এখানে আমার তো একটা আমরা আসলে খুশি হই আমরা এক্সটেন্ড করতে চাইছি স্যালারি পারসন কিন্তু
Yes.
The affidavit of asset was filed by the husband. That will not contain bank accounts of not some of the accounts. There are numerous accounts. Some of the accounts of the husband. The bank accounts disclose not influx, lord, and disbursement of crores of rupees. Now he is saying that he is a salaried person. If it is a mere salary, my lord, there is no explanation how, my lord, several crores of rupees are coming.
Where is the affidavit of asset filed by the husband? This is the affidavit of asset.
He is an immensely well.
What no?
My revisional application contains their assets, my assets, and other documents also.
Without annexures. He has filed the affidavit portion without annexures. This is not entire affidavit. Now, my marker. Now, Lordship will kindly not come to one of the. Page 168, my lord.
168.
My lord.
This is
He
the
has given,
pagination.
my lord, in page 8, my lord, he has given the particulars of the accounts, page 8. The accounts that he admittedly, my lord, is having his accounts with the banks, page 8, serial number 9. I am, my lord, relying on serial number 9E, account number, my lord, last 4 digits 4815 with Punjab National Bank. 4815, last 4 digits. 9E, page 8, 9E.
168, page 168.
No, Page 8 is the affidavit portion. Page 8.
8.
Serial number 9E. This much we can, as layman,
Serial number 9B. Yes.
9E. Account number last 4 digit 4815. Punjab National Bank. This is not at page 168.
Page 168.
168 of the affidavit of asset. Your affidavit of asset. Now, if your lordship, my lord, takes up this affidavit of asset, my lord, your lordship will find several entries, my lord, coming, my lord, several entries where, my lord, the amount is coming and being paid to the family members of the husband. Your lordship kindly takes up page 116. 8 back portion, backside, my lord.
This is the account of the petitioner.
Account of the, my lord, husband.
Oh, sorry. Yes, husband.
Husband.
Husband
Now,
is also a petitioner. Husband, yes.
One of the petitioners. Now, your lordship will see, my lord. Kindly come to the second page, my lord. Page number 2.
No.
45.
Page?
Page 2. Page 2 of the, my lord, account. Kindly come, my lord.
Yes.
Kindly see. Sushila Kedia, amount paid is 15 lakhs. Then, my lord, next entry is he is getting 15 lakhs from Pearl Industries. Then, my lord, similarly,
Sheila Kedia. Sushila.
Yes.
Oh, yes.
Mother.
Yes.
We have, my lord, calculated, my lord. He has paid, my lord, 80 lakhs. In the year 2022-23, my lord, total amount paid to Sushila Kedia is 25 lakhs 50,000. We have just calculated the entries. 25 lakh 50,000. And 2023-24, he has paid 43 lakhs to mother. Amounts are coming, amounts paid to mother. Balance sheet shows there is no income. This is how mother and sister, total amount paid to sister is, my lord, 22-23 is 4 lakh 89,000 and 23-24 is 87 lakh 50,000. He has paid to sister. So total, my lord, several crores have been paid to family members, also to nephew. And the amounts are coming from various, my lord, companies. And he is saying, I'm a salaried person. I have an income, fixed income he has shown. His income he has shown is 4.2 lakhs per month. Court has given, on the basis of that, court has given 80 lakhs.
Where is the income tax return?
Income tax return.
Page 4950, my lord.
49.
4950. Here, he has shown 45 lakhs, but the money is going to mother and sister that he is not showing. Only one account we could not ascertain. And he has several accounts. He has received 93 lakhs 19,000 from 3 companies and disbursed 1 crore 30 lakhs to his family members in this one account. In 2023-24. And 22-23, he has received 1 crore 76 lakhs and transferred 83 lakhs 25,000. This is not reflected in the income tax account.
Yes.
Now, my lord, trial judge has relied on page 450, my lord, the income tax return only. But the bank accounts have been totally ignored, although it was part of the, my lord, affidavit of assets. And we could not ascertain from one bank account, if, my lord, a chartered accountant, my lord, makes the calculation, actual income could be, my lord, ascertained. The court has not done that endeavor, my lord, or court should have, my lord, at least, my lord, gone through the accounts and assessed, my lord, by lifting the veil, what is the actual income, which was not done. One, court has taken this, my lord, IT return, and it comes to, my lord, 4.2 lakhs per month. and the wife has not some income. 3.5 lakhs yearly is from interest. Some FDs are there. Total 3.5 lakhs is her income from interest. That has been considered and 80,000 has been given. But this portion has been ignored. Now it's not possible for us, my lord, to make the calculation what is the total incoming amount from various accounts. But a salaried person will not get these things unless he has some business. This is the position. But if a chartered accountant is appointed, my lord, a trained person, he can, my lord, assess from the account various accounts, my lord, what is the actual income of the husband. That endeavor has not been taken by the trial court.
Where is your application?
My application.
What was your claim?
Claim was page 73, my lord, 5 lakhs.
Page 5 lakhs per month.
Commensurate with the status of the husband, because my lord, he is having so many companies. My lord,
Page
73, my lord.
Yes.
Initially, it was lesser amount. Amendment was filed and it was enhanced to 5 lakhs. Original application is not page 17.
73 is the amended application.
Amended application. 17 is the original application.
Yes. So amendment allowed, so we have to go by this.
By this, my lord. Now, my lord, in my humble submission, my lord, the affidavit of asset, my lord, if gone through minutely, my lord.
Where is your affidavit of asset?
My lord.
You have also not annexed, Mr. Banerjee.
No, mine is annexed. In my revisional application, no, both of our affidavit assets are annexed. They have filed, my lord, 2 affidavit of assets. My lord, I do not know what has been handed over to your lordship.
That's 18th April 24th.
Second. Count.
What is your income, Mr. Banerjee?
3.5 lakhs yearly from interest, from fixed deposits. Yearly.
Expenses for education, any children there?
Son.
Son is with you.
Sure. Now attend majority. Now attend majority, but.
No, attend majority means class.
He is now pursuing
21 years old.
BTech course.
BTech. Still not in service.
Not in service.
I am taking care of my son. Milord, there is no
not taking
bargain on.
No, so this is apart from the son.
It's only with respect to the wife. Milord, whatever the expenses
No
of
money
son
is
is
paid,
required,
only
Milord,
the
I am
tuition
taking
fees
care
are-
of everything.
Tuition fees are paid. Course fees, I am told, father has paid. Apart from
No, Mr. Banerjee, from your monthly expenses in the affidavit of assets, page 2, some you have given by annual, some is monthly. What is the monthly expenditure according to your calculation in the affidavit of assets? I find a figure of 1,51,000 written by hand. So it is the correct figure, 1,51,000 per month.
Possibly this will come to 2 lakh, 1 lakh, 3 lakh.
5 lakh something, right?
No, 5 lakh.
5
I
lakh
have
6,000.
paid in my amended application 5 lakhs. This was possibly
Maybe the affidavit of asset. Affidavit of asset, I am asking you this calculations which you have given for your monthly expenses. Some are in per month, some are in annum.
1.5.
So 1.5 is your
Come
expenses which you have calculated.
Roughly, my lord. Initially, এটা দে না প্রথমটা দে প্রথমে কত ছিল আমার
প্রথমে তো কম চাপা ছিল।
17
So you are having a car.
The car, not that 15-year-old car, it is.
No. So
there's no.
you are not using the car.
I cannot because Lord, now the registration has failed and it cannot be Lord, renewed anymore. More than 15 years old. This is also one of the prayers that he should provide one car with a driver.
But you have prayed for both public transport, car fuel and maintenance. How can it be both?
The son was at that point of time went to
Now it is not there. So you cannot get both. You are saying public transport as well as car fuel, as well as driver. How can it be?
But if Lordship will ignore the public transport. Now son has attained majority. And son is, he bears not public expenses, transport expenses, but he is now pursuing his graduation in an engineering course. But the other requirement remains.
LIC.
Your electricity expenses is only 2,000 per month, Mr. Banerjee.
That was claimed at that point of time. Subsequently, an amendment was made.
At what point of time? This affidavit of assets was filed in 2024.
My lord. 24.
This shows the level of your expenditure. It's a reasonable expenditure. But the other expenditures are not matching with the electricity
Grocery.
So considering your lifestyle.
Lord, C is grocery. The second item.
Grocery.
Yes, grocery is
expensive.
You may not have that experience, Mr. Kormakar, because
somebody takes care of.
Yes, so you may not be knowing the cost of
grocery, food items, clothing.
Yes,
personal care, everything.
from these items, yes, perhaps you are not doing those things. You do not have any idea of that. Mr. Banerjee takes care of that. Yes.
Lord, medical 15,000 per month. She is not sick. She is not suffering from ailment.
It is a specific case that there are medical expenses, my lord.
Per month?
Yes. Recurring expenses.
No, she is ill. She has not certified that.
It is under affidavit.
The affidavit, so I have also.
I am relying on an affidavit only.
No, affidavit to counter affidavit to আমিও করেছি.
Yes.
So, my lord, in my humble submission, my lordship, your lordship has seen the husband's affidavit of asset. Not one particular account I have shown. I cannot. I am not a chartered accountant. I cannot go through all the accounts and come to a finding or a conclusive finding what is the actual income. But this particular account, the incoming of more than 1 crore and payment of more than 1 crore to the family members, this clearly shows me that apart from the director's salary, there is much more. Lordship will kindly appoint somebody.
Yes, Mr. Kormakar.
Let him
Let an expert be appointed
Lord, with respect
to
Lord, with
go through the accounts of both husband as well as the wife.
Lord, only two things, Lord, I'll indicate before your lordship, whatever your lordship feels like. Lord, kindly takes my revisional application once. Lord, it has been stated that I am a salaried person. Lord, where from Mr. Banerjee, Lord, is getting that, Lord, I do not know, but kindly, Lord, takes the trouble, Lord, to come to page 118 of my revisional application. This is my affidavit of asset.
You are not a salaried person, Mr.
This is what I have stated.
No, I am asking you. Are you a salaried person? Yes or no?
Stated or no, I am doing business. And the business,
So
I get money
then
from
how are
as
you
director.
How are you claiming standard deduction, Mr. Kormakar?
As director, the salary is on account of as director.
Yes. So standard deduction is allowable only with regard to salaries income.
Absolutely.
So
The
don't
salary
say
is from
that you are
director.
not a salaried person.
It's from director.
Yes. So
Now,
director salary comes under salary,
kindly sees
which
180.
entitles you to get standard deduction. If
Yes.
you are not a salaried person, you will not get standard
Now,
deduction.
Lord, kindly comes to my
Yes.
Kindly comes to 123.
Yes.
F. I have indicated, Lord, the source of my income.
123 F. Yes.
123 F.
Yes.
And I have also indicated, Lord, where I am acting as a director, discharging my duties, but not getting any remuneration. Lord, your lordship knows
none of these accounts, because everything is through bank, none of these accounts can be tampered. I have to disclose this before the income tax authorities, and that's exactly what I've done. And that's how, my lord, I filed my, lord, income tax return. So, my lord, when these things, everything is on record, my lord, despite that, and I've also indicated, my lord, kindly comes to a chart. Chartটা কোথায় গেল? হ্যাঁ, my lord, kindly comes to page 240.
Under what heads you are earning, Mr. Banerjee, Mr. Kormokar?
Lord, as I have indicated that as a, in F, my lord, page
Yes.
2.
Show me your statement of total income.
Yes.
The
Lord,
heads under which you are earning.
123.
123 is not the
Details of
statement of
income
total
of the
income.
details of the income of the deponent.
Salary.
Yes.
I want to know the supporting documents with your income tax returns.
51, page
Which
51.
Are
51.
only 51.
Page 51 of affidavit of asset, my lord.
Oh,
Husband-
affidavit of assets which you have handed up.
Yes. এইখানে।
নেই তো? আচ্ছা। না, annexure তো নেই। হ্যাঁ, এই তো salary 38,005 years such and such.
Yes.
Standard deduction such and such.
Where is your business income?
Other source of income. But perhaps at this point of time, because kindly sees, my lord.
You said you are a businessman. Where is your business income disclosed in your income tax return, Mr.
Lord,
Kormokar?
I have indicated that I am doing business in the recital.
Where is I'm asking you, where is your income?
Kindly comes to 127.
127 of this affidavit of assets.
My lord, page 10 of the affidavit of asset.
Page 10.
of the affidavit.
The bunch with Mr. Banerjee has handed up.
Page 10, internal page 10.
Yes.
Self-employed person, professional business person, such and such.
Page 10.
Applicant is a
Salary.
salaried individual. Brief description of the nature of business. I am engaged in the such as company and earning. Oh, I'm sorry.
No, page 10 I have got.
Page 10, I.
Salaried individual.
Yes. Thereafter, I'm engaged in the aforesaid companies as director and
Earning salary.
The said company is engaged in the business of manufacturing of soft coke and trading of coal and other activities.
Yes.
So, this is how I am related to that.
No, so,
I'm engaged
so
in the aforesaid
you
company.
do not have any business income.
Not as such, but
When Mr. Banerjee said, you said why? Who
no,
said?
this is only on that, not the business in that sense. Now, my lord, kindly says, I am engaged in the aforesaid company, they are earning from salary. The said companies are engaged in the business of manufacturing, so the same. Now, my lord, kindly comes to this page 51. Your lordship finds whatever I've disclosed here is exactly what is, my lord, reflecting in here. I've taken instruction. I have no, my lord, difficulty. My lord, if your lordship appoints an expert to go into both of us, both of ours, my lord, accounts, and my lord, find whatever is required. I have no difficulty. I'll come clean on that.
Mr. Banerjee, your accounts also has to be inspected.
Both.
No
Only-
difficulty.
And one more thing, my lord. He was paying at the old rate of 30,000, but last 2 months also, that is also 125 order. That is also stopped for last 2 months. Let them, my lord, at least 80,000 is awarded by the trial.
My instructions
Let
are
him
we are
pay-
paying.
No, 2 months.
80,000.
30,000.
30,000.
30,000 I'm
That
paying.
also 2 months due.
No, the reason why I tell you,
Mr. Kormokar, even if going by this statement of
please,
accounts
Lord,
at page 51.
this your lordship is seeing for today. Lord, kindly comes to page 248 once.
Today means it's
I'll
2023.
indicate why. I'm indicate why, my lord, I'm saying that. Kindly comes to page 248 once
Of this affidavit of assets.
of my application, of my revisional application.
Of your revision application. Yes.
Your lordship would take, my lord, I'm sorry.
What is the stage of the suit?
Stage of the suit.
Execution also.
কি স্টেজে আছে? কি স্টেজে আছে? একটু জিজ্ঞেস করো। So I shall find out. Your lordship has seen 248.
248, yes.
Lord, kindly sees from the third, my lord, row, because the first 2 rows are irrelevant, not required. From the third row, the date of when the application was filed. At that juncture, my lord, my income was not, my lord, the one that I earn today.
So, my lord, if the test is the wife will get commensurate income of my lord, maintenance to my income.
When the application was filed?
2014.
2014.
Yes. And the trial learned trial judge directs payment of today's maintenance since 2014. That will not perhaps
I'm
cannot
not
be
asking for arrears at this moment. Let him, at least today he is earning.
Cannot
So
be.
today's rate, let him pay 80,000 from now on. I'm not asking for arrears at this moment. He says that there should be some reduction for the previous years.
It cannot be standardized. For last 10 years, no development, nothing has been considered. At a straight jacket formula, the maintenance amount has been imposed.
What is the total amount arrears coming at that rate? What is the total due?
Total due, as per my calculation,
at this rate,
direction,
at this rate,
80,000, what has been decided, it comes to the area should be somewhere around 73 lakhs. 73 lakhs 92,000, such and such. That is perhaps not, that cannot. It has to be reconsidered.
And so from Mr. Banerjee, that is also he has some substance on that.
After your lordship takes up the report regarding the income of the expert, your lordship will fix a certain amount, X or Y.
Instead of that, I am relegating to the learned trial judge. Let that be done there. It's better because
somebody, at least your lordship after
because Mr. Banerjee, after all, it has to be decided. You can have your say there.
It has
because
been reappreciated.
Yes, it has been.
Whatever my Mr. Banerjee is indicating, those things that means reappreciation of evidence again.
I only say, that the court has the record with the record, the affidavit was filed, which contained the accounts. He has not gone through the accounts at all. He
Mr.
could have easily
Banerjee, at this stage, is it possible for a court to decide then Section 24 application will not be decided in near future? They will be appointed, they will investigate, a report will be filed, both of you will file objections against the report against that.
Let the report come, then your lordship reminds back. Otherwise, if your lordship sends back, it will take another 5 years. Somebody will be appointed. Lordship kindly, she is not getting anything. 73 lakhs is due as per his own admin.
Not the case that she is not getting anything.
That is why I am saying, let him pay at the.
And both of you cannot come to a consensus with regard to this.
What
is the stage of the matrimonial suit? Instead of fighting with this alimony, it will go on. It will not end. Mr. Banerjee, even if I appoint, I think both of you come to an agreed figure.
Mediation.
Lordship will appoint the
mediation.
The first thing, I had a talk with my client, was this. He said on numerous times in the before the learned trial judge, sittings had happened, but did not fructify. So,
mediation for what?
For both, for maintenance, for the main suit, everything.
If you can come with instructions, what is the suit for?
The suit is for divorce.
Suit for
divorce.
Suit for divorce filed by husband.
No counterclaim for restitution.
No.
Whose suit is that?
Husband.
My
is it possible for reconciliation, or you are seriously contesting this divorce?
She is Miller.
Then what mediation? What purpose will mediation serve?
Is to this financial
the mediator can convince the parties. There might be a consensus decree also, decree by consent also. I don't know what will happen in mediation. If your lordship thinks it is a fit
I had
case,
a talk with my client.
There are two things, Mr. Kormakar, if you say with regard to the maintenance also. So I will appoint someone who can decide on this maintenance aspect as well.
But I do not have any difficulty.
An expert in this accounts field.
But I will never
trained mediator, I can tell you. So he can
take care of both.
Yes.
But I will not stand in the way, of my lord, appointing someone,
please take instructions.
Problem can be
take instructions. I think if that is so, with otherwise appointing someone.
With respect to accounts, I have taken instruction. There is no difficulty.
Yes.
There is no difficulty. But with respect to, my lord, this mediation factor, my lord, I have taken this instruction on the very first day. My lord, he said numerous times this has happened. My lord, it's a complete waste of time. The only reason is
Our only difficulty is that I can appoint that, but that will not end. Once the report comes, both of you will file objections against the report against
has
us.
to be, has to
So it will not end. That
Has
is why I'm telling you, if both of you can come to a consensus either way, may not be by appointment
Look,
of a
here is such
mediator.
a situation where the wife is not dying out of blood hunger. It is only the situation
the
that
maintenance.
she wants a commensurate life.
She has no income.
That's exactly
But Mr.
which
Kormokar,
detailed also.
but Mr.
I'm not for a
Kormokar,
second saying she's
from the
wrong.
statement of accounts as projected, it appears that something is there.
No, that I,
Because I've seen
if
the
something-
accounts, I've also seen the computation.
Lord, if something would have been
Because
there,
some calculations, right now I can hold that some incomes ought to have been included,
Lord,
which
if
deductions were
More
taken.
than,
Lord,
more than
if
1.7
now, Lord,
crore.
Mr. Kormokar, it's one thing for you to get a tax deduction under the Income Tax Act, but it's the other thing whether that deduction, that amount which was exempt from income
to be
tax,
considered
will
in
come
for the
for the
factor of
purpose of computing the alimony or not.
Yes.
Some of the income which may be exempt under the Income Tax Act, which has been excluded, the learned trial judge has proceeded on the basis of that. But while calculating alimony, that cannot be excluded.
Lord, with respect to
There's
that,
no
Lord,
reflection of
there
those
was
amounts.
That is why, without making any observation, if both of you can come, I can both of you can come to a consensus figure, I can also say, yes, Mr. Banerjee, because this amount cannot be from 2014.
I understand, Lord. I
So
understand.
you also make your client
I-
understand, if both of you have a talk between with Mr. Kormokar as well. So if a consensus with regard to the alimony can come, I can direct that amount and the suit to be
At
discussed.
today's rate, my lord, today at least, my lord, the amount is justified. If
That
today's
is-
income is
That
so it's
Mr. Banerjee is,
casually reduced, my lord, for the previous years.
yes.
That I understand. I'm not objecting to that. That's the logical thing he has said. But so far as the arrear, my lord, it might reduce, but let him pay some amount, my lord. He's
But
going
my
on paying 30, that is also stopped.
my instructions are, my lord, she is
2
being
months
paid.
due, 2 months due, that is also 30,000, not 80,000. At least
Lord, my
today's
instructions,
rate, let him
Lord,
pay.
So Mr. Banerjee, that will be the final order. I cannot now direct him to pay something more.
Fine.
If he volunteers to pay something more, that
I
is,
shall take instruction, Lord, in that.
yes, because
let him pay
after all, you have to, even whatever is the rate,
Yes, yes.
because there are some
Something I have
areas,
to
it
pay.
cannot be 30,000 also,
Something I have to
cannot
pay.
be 30,000 also.
No,
So
that
if
I
you can-
understand. That I
If you
understand.
can make a good
I have
gesture,
indicated that, my lord, to my client also. My lord, that something he has to pay, and that has to be in addition to 30,000. Lord, that goes, Lord, out of the window if I
Today's
make
rate,
that.
what I would be submitting today's rate is not unjustified. But what Mr. Kormokar says that 2030 it was low, that I understand. So I was saying to at least today's rate, let him start.
right? So can you take instructions and come back on this mediation, which Mr. Banerjee says?
Yes, my lord, keeps it tomorrow, my lord, I shall take instruction.
I'm keeping it tomorrow. You can take instructions.
But with respect to holding inspection, mediation, my
tomorrow.
lord, 1 day's instruction is good
Day
enough.
after tomorrow.
If he says yes, if he says no, whatever the outcome is.
Day after tomorrow.
In
In the same position, my lord, at 230, some time maybe fixed, my lord, otherwise.
After these matters, same thing,
Same head, same head.
under the same heading.
Same
Yes, call the next matter.
Same head. Same head now.
Yes, call
1334.
1334, yes. Yes, Mr. Rai. You are appearing.
Yes. আমি একটু ছিল
তো রিভার্ট ব্যাক হয়ে গেছিল, আবার এখানে এলো কি করে? Right,
Mr. Mukherjee
was
was-
directed to be reverted back to the original position, since you had not given notice for upgradation. How has it again come under the heading upgraded matter?
After that notice given, other side mentioned that after that again given. That is why.
My lord, Mr. Devjit Mukherjee is happy for this matter, my lord. He came, but due to his illness, my lord, he left the court early today.
Convince him.
I am already.
One day accommodation, my lord.
What is the order impugned, Mr. Rai?
Order 12 rule 6.
Order 12, rule 6. Judgment on admission. What is the admission?
Their occupation charge is more than 10,000. It is admitted from their plaint itself.
Occupation?
Their rate is more than 10,000. It is admitted in the plaint itself. So they are not entitled to get in protection under the Original Persistency Act. And they have admitted the notice. On the part of the point, my lord was pleased to, sitting with my lord Justice Sen, was pleased to hold that once it appears that it comes within the purview of Transport Act and you have replied to the notice, there is nothing remains for consideration.
They replied to the notice, they have admitted his rent is more than 10,000. Admission order to
Where is that?
What
is the impugned order?
That I can do, but
Mr. 27 hour.
Then you will also turn to the plaint itself, then it will be.
So what is the suit for?
They are
Suit
suit
is-
for declaration of tenancy right.
Their suit is for declaration of tenancy right.
My
So suit is for eviction.
Yes.
Under the Transfer of Property Act.
Yes.
Yes.
Now, if their suit, previously they have filed a suit also. That thing also mentioned where you are categorically mentioned that rupees 190,000 per month is the rent. If that be so, then my lord, he is not coming within the purview of Original Persistency Act. And notice I have issued that they have replied that yes, this notice is bad due to. Hey, they have replied to that. Then what? I put this question to myself: if I prove these two ingredients, what remains for the purpose of adjudication? Not the entire suit, my lord. A part degree can also be granted under Order to Rule 6.
What part degree you want?
Eviction, the main profit will be considered and other things will be considered later on. Why my eviction will not be?
Give me the decision.
Showman Savage judgment. No, Showman Savage judgment. Division. Oh, yeah. 18, 19, 20. কিন্তু আমি মামলা করবো কি করে বাবু? বুঝতো?
$40 document, 75 also.
Sir, this was on a first appeal.
Yes.
Arising from what?
Order Rule 6 allowed. Allowed. I cannot be vexed twice. fire which is relied upon. And their statement 49, page 49, you will find. And not only that, ultimately it was directed to execute.
Show me where is the admission.
Yes, one can turn to page 49. And the documents, আগের প্লেটে যে 19,000 টাকা ছিল সেটা বার করো। Page 49. Yeah. That apart from the monthly rent of rupees, other plaintiff also paying maintenance charges 5,000 and electric charges rupees 10,000 per month. That is such abnormal illegal demand. Enhancement of rent cannot be accepted, not acceptable to the part of the plaintiff.
No, monthly rental is 4,000.
And maintenance charges, fixed components. Fixed component. It is not a variable component. Once while at the tenancy, if you want, on the basis of fixed component.
Those are to be decided.
Well, hey, what is the judgment? My lord is not. It is their statement, their fact.
No, Mr. Rai, there are two things. One is what you are saying is if electricity charges and maintenance charges are fixed amount is being paid, whether that will come within the definition
of rate.
That's one thing. Now here, Order 12, Rule 6 is admissions are to be clear, unequivocal. Here, their case is that apart from monthly rental of 4,000, he is paying these things. So according to him, monthly rental is 4,000. Apart from that, these are being paid. According to you, this has to be combined and the rent is. So that has to be decided, Mr. Rai. That has to be decided. Yes. You can take advantage of that decision. No. But according to them, it's not admitted that yes, rent is 19,000. This is not admitted.
No, now, my lord, if your lordship once, my lord, I bow down to your lordship. Can you turn to page 45?
Yes. All right, let him come.
Page 45 once. What is followed from lordship? I want to.
Page 45, yes.
5, paragraph 5.
Yes.
The defendant number 2 on behalf of the defendant number 1 putting his handwriting at the overhead note and it is lying on
paragraph 5.
Paragraph 5, page 45, internal page 4 of the plain.
Yes.
Relevant.
Oh, yes. You are placing from the middle. I could not.
Paragraph 5, it is like the. Now they have annexed this document.
So agreement was made between even the defendant has never issued any rent precedent, rather the electricity charges, monthly rent as well as were duly received. Monthly rental, according to the defendant, is a separate.
Page 73. Can you turn to page 73? Apropos to this, can you turn to page 73?
Yes.
I am not relying on my document. It is their document.
No, their document.
Hand notebook, rent receipts, well, got it?
Yes.
Can you consider what is the amount?
What is, where is there? Oh, yes.
29,000. This is my case in the release statement also.
Rent?
29,000.
29,000, how it comes?
75,000 last line was 75,000.
How it is 29,000?
According to us, it is 29,000. Keeping aside.
Per month.
Per month.
But it is, Mr. Rai, it's August and September 29,000 cannot be per month.
Last page rent it
is 2010 while I was looking 2010 after that 70 page 75.
75 yes.
58,000.
58,000 Malad got it. 58,500 for 3 months. 14,11,11 Malad got it. 90,500 per month.
August, September, October. November, December, January. 58,000.
I'm keeping aside. It is their document they are relying upon.
106.
What more I have to prove, my lord?
Yes.
That I'm not opposing some of the adjournment discussion.
Opposing.
আমার ঘাড়ে অত কথা নেই আগের দিন আমি বলেছি অপোজ করেছি নাকি
He says after a week you have accepted that.
No, acceptance of the after we get it time মরে যাবে একে
Number 151.
মানে কালি
1-8.
written disposition so I can
After a week. After a week it will come. Under this heading, but after a week. Under this heading, yes, next.
কি থাকবে হ্যাঁ এই যে ও হাসছে কি but somewhere getting information getting the posting of matter is very hard.
Yes.
And this the matter mention matters.
It will appear under this heading. I told you after a week. Under this group.
Making not this week well and there well and it will suffice the purpose well.
Yes.
Other
Everything will suffice. Yes, Mr. Haldar. Yes. Yes, where is the other side?
My lord, on 2 occasions, my lord, pursuant to the direct.
The contested application.
No, kindly have a look at this.
Yes, this was directed to appear under the contested application.
Maybe, but liberty was given, my lord, to mention for upgradation, my lord.
Not contested application. Not contested application, Mr. Haldar.
My lord, I am suffering, my lord. This is a very short matter application for local inspection. My lord, he will not be prejudiced in any way, my lord. If the
other side is not here, Mr. Haldar. How can it be done?
What can be? I filed, my lord, on 2 occasions, my lord. I served
notice for upgradation.
Notice for upgradation as well as, my lord, the service of this divisional application. Both the occasions, my lord, they received.
Yes. What is the matter?
Plaintiff is the petitioner before your lordship. My lord, suit for declaration, partition, and permanent injunction. My lord, ad interim injunction was granted, my lord, directing both the parties, my lord, to maintain status quo with regard to the joint possession and also, my lord, changing the nature and character of the suit property. My lord, in violation of order of injunction, my lord, they are disturbing my possession, my lord. I took out an application for implementation of the said order of injunction, my lord. That was also allowed. And, my lord, the local Baduria police station was directed, my lord, to implement the order of ad interim injunction. My lord, initially, my lord, in violation of order of injunction, my lord, they, my lord, broke down my lord, bamboo fencing, my lord, over the property in question. I took out an application for repair of the same, and that was allowed by the learned trial judge. Subsequently, this is for the second time, my lord, they, my lord, pulled down the, my lord, the bamboo structure, bamboo, my lord, fencing. Now, my lord, I took
Where
out
is your application for local inspection?
my lord, at 45.
45.
I took out an application for repair. In aid of such application, I took out this application for local inspection. Initially, commission held. It appears from the report, my lord, there is a, my lord, bamboo fencing that is surrounded by the property in question, my lord, which the plaintiff is in occupation. Paragraph 3 onwards.
Yes, what are the points of local inspection? Page 47.
My lord.
Where is the application for repairing?
My lord, prior to that, my lord, page 40.
40, yes. Yes, your prayer is to reinstall the bamboo fencing.
Yes.
So you reinstall that. How these points will help you?
No, no, my lord.
Please kindly come to page 47.
My lord.
How these points will help you?
So far that application is concerned, that is pending for consideration.
Which application?
Application for repair.
Yes, in aid of that, this application has been filed.
My lord.
So your application, prayer in the application was that you have to because there was a bamboo fencing that was demolished. You want to reinstall that.
My lord.
Now, please kindly, in aid of that, this application has been filed.
My lord.
So only purpose is to reinstall.
My lord.
Now, kindly come to the points. How that will be relevant for this?
Prior to that, my lord, kindly have a look at
Details and descriptions of the trees,
Yes,
details and
38.
descriptions of the houses. How that will help?
My lord, kindly have a look at page 38.
Yes.
38. Earlier report.
Earlier report, I am not on that.
No,
Earlier report.
Just I'm.
This is maybe Mr. Haldar.
But
Earlier
kindly
report,
look at-
whatever it might be.
Have a look at page 38.
Yes.
My lord, in the middle portion, left hand side, বাঁশের ছটা বেড়া.
Yes.
So, my lord, on earlier occasion, my lord, that was still standing there. Now, my lord, they have demolished in order to show
So
that.
take the help of this local inspection report. There is no necessity of a fresh inspection report. According to you, this was there.
My
This
lord.
has been demolished.
My lord.
Take help of that. No local inspection is
No,
necessary.
how can I, my lord, prove that they are saying, my lord, they have not done this.
Sir, please see the in points. None of the points are with regard to this fencing.
Other local features are shown at the time of commission.
Please, houses, hand sketch map of the house property. How this will help?
Other local features are shown.
Other local features is
Only to show, my lord. Well, only to show that, my lord.
this application under Article 227.
that the suit is fixed in the framing of issue. But so far as the point number 1 is present position of the entire suit property need to be stated. Entire suit property. Make an appropriate application.
Document fixed matter.
And make it clear.
It's clear. Without liberty, he will not file any application, Mr. Alda.
Just true,
File this application without liberty.
Every service will be kept with the record.
Every service, yes.
49. Yes. 49.
Yes.
The opposite party. To add more volume to your brief, my lord, these are additional
What is
documents.
that?
The additional documents, my lord, this contains, my lord, the comprehensive list of dates as well as, my lord, the other documents which they have missed out.
Supplementary list. Yes. What is this?
This is their revisional application, and my lord,
Sure, revisional application arises out
granted
of
by your lordship. My lord, this is our, my lord, comprehensive list of dates along with the documents which they have missed out in the revisional application.
Yes.
But I have served him today.
Then
I don't know.
how can he get himself ready?
Next week.
if any other day.
But in that event, my lord, I have one more prayer since Mr. Promit Roy is, my lord, leading me. My lord, he is in personal difficulty till 19th. So in any other day after 19th will be, my lord, feasible for him, my lord.
The learned advocate appearing for the opposite party. Yes, next.
I took the point of maintainability and Mr.
Point of maintainability of what?
Because my lord, from section 7 order, my lord, directly, my lord, they have filed the civil revisional application. So my lord, I relied on the Studio Devi judgment. On last occasion, Mr. Bhattacharya was arguing.
Yes, where is he?
My lord, his,
outside is coming.
Yes.
my lord, his submission was on last day that the point of limitation was erroneously decided.
Yes, he relied upon, I think, two
portion
decisions.
of the impugned order. So my lord, I will, my lord, basically want to fall back.
Mr. Bhattacharya has concluded.
No, not concluded.
Start. He said he have concluded.
আরো বলবে?
The only issue which will trouble your lordship is in the facts of the.
According to you, though there is an appellate remedy available, but since it goes to the root of the jurisdiction,
Well, this is in violation of natural justice. I was not heard.
that is
I
why I'm
was not
saying.
heard.
Also the point of limitation you took.
Limitation is a by way of an application, which contained, in number of judgments. The learned estate officer, relied on the judgment cited by the private party. Private party means, the intervener. Not relied on anything, insofar as we are concerned. He had closed the hearing. 17 June is the first order made in the proceeding.
Yes.
And thereafter, there are two applications, both by us. Those two applications, indicated, in the application that we want a hearing. Kindly grant us an opportunity of
Yes,
hearing.
you relied upon two decisions, 2010 4 CLT and 1976 3 SCC. Mr. Nag referred to. Yes. So in support of his,
I have handed over to your lordship, 2025 volume 4 SCC page 1.
I will just take today 10-15 minutes and conclude.
yes.
Now, this is 125 volume 4 SCC page 1. Kindly see.
Who will argue? You will argue or he will argue? Please decide. Who will argue?
Point of maintainability was the issue. Now
Yes.
he wants to submit on merit and
No, no, no.
No, this is on maintainability.
On the maintainability
Yes.
itself. You have submitted, you have relied upon, he started, he did not conclude yes on the last occasion. Yes. His judgment.
Milord, I will hear his arguments and I will respond. Let him make his submissions. Milord, the fact remains, he has to justify only one thing. If he has a case, he has the, let us assume he has the best case.
Yes.
He has to justify as to whether the estate officer extended an opportunity of hearing to me on my application that was taken out on the question of maintainability of the proceedings initiated by the estate officer apropos the notice. That is the sum and substance. If he can persuade your lordship, Milord, then I will respond. Otherwise, Milord, the issue is only this much. The matter, according to me, it should go back to the estate officer for an independent assessment.
You have relied upon 2025.
Different estate officer.
2025-4 you have handed up, but you have not placed in that sense. If you want to rely upon, you can rely upon that.
Please come. Milord, 54 to 63. এরা বলেছিলাম ভাই আগের দিন জজ সাহেব বলেছিল জাজমেন্টটা নিয়ে এসো।
না আমি কপি দিয়ে দিয়েছিলাম লাঞ্চ।
Now please see from paragraph 53 onwards at page 14.
Paragraph 53.
My lord.
Yes.
The issue, therefore, which arises and needs consideration is whether there would be an absolute and complete bar to invoke writ jurisdiction under Article 226 of the Constitution, even in exceptional and rare cases where fairness, equity, and justice may warrant the exercise of writ jurisdiction. Access to high courts by way of a writ petition under 226 is not just a constitutional right, but also a part of the basic structure. It is available to every citizen whenever there is a violation of their constitutional rights or even statutory rights. This is an inalienable right, and the rule of availability of alternative remedy is not an omnibus rule of exclusion of the writ jurisdiction, but a principle applied by the high courts as a form of judicial restraint and refrain in exercising the jurisdiction. The power to issue prerogative writs under is plenary in nature, and the same is not limited by any provision of the Constitution and cannot be restricted or circumscribed by a statute. It has been well settled through a legion of judicial pronouncement of this court that the writ courts, despite the availability of alternative remedies, may exercise writ jurisdiction at least in 3 contingencies. Milord, we are covered by the first contingency itself.
Principles of natural justice.
Yes. Where do we come? Milord, please take the trouble now, Milord, just to show prima facie, Milord, the facts once, just 2 minutes. Milord, first come to page 65 is the first notice. Page 101, kindly marks it, Milord. 101 is my 17th June order. 65 is the first notice to which I respond. And then, Milord, page 101.
Yes.
Please see page 101. 65. Response is page 67 onwards or 66 onwards. And then, Milord, 65 is the show cause. 65, then 101.
$65 is the show cause notice.
Yes. Milord, then is 17th June. Prior there to, Milord, at page 100.
No, 65 is 20th of May.
Yes, that is the notice.
Yes, yes.
Calling upon me to show cause.
Yes.
Then, Milord, page 100.
100.
Yes.
Yes.
Sir, I'm sorry.
101.
Page 99. I'm sorry. Page 99.
Yes.
Today, the matter was fixed for hearing. Today, the opposite party has appeared in the proceeding and sought time to file application before the estate officer. So OP1 is seeking adjournment of today's hearing for a short period, enabling the OP1 to file such application. Is made bona fide and for the ends of justice, Milord signed. Then Milord, 18 June, page 100.
Yes.
I send here with original notarized application for your information and necessary action. You are requested to grant an opportunity of hearing of the application by giving an early date to the applicant. Thereafter, Milord, I have appended page 101, 17 June 2025, the order passed by the Milord estate officer. Kindly sees, matter was fixed for final hearing according to the parties were directed to place the verbal submissions, the learned advocates on behalf of Martin Barn, opposite party herein, and such opposite added party herein had placed their respective verbal submissions. The respondent SMPK had submitted. They had already filed documents in support of their. However, during the course of hearing, on behalf of Sotto Doctor, kindly ignores it. Further, learned advocate on behalf of Martin Barn has also filed.
Martin Barn.
I am Martin Barn. Has also filed an application seeking adjournment to file an application before this forum. Peruse the application filed on behalf of Martin Barn and consider the matter. It is seen from the records that opposite party and added party had already filed their respective reply to the show cause on 20th May 25, and subsequently SMPK has also filed their comments, not served. These comments have not been served with regard to the same. Therefore, in view of the hearing of the matter is concluded. Then it is needless to mention that such and such act provides a procedure for speedy and summary disposal of cases. Hence, all the parties are at liberty to file written notes of arguments, if any, within the such and such date. The learned advocate is also at liberty to file further application as paid for within such time as mentioned above. I shall take into consideration the respective contentions of the parties at the time of passing of the final order on the basis of the documents filed by all the parties. And thereafter, my lord, at page 102, I filed the second application, indicating that on 19 June, I have been handed over by my client an order dated 17 June, passed by you. My client has received the order on 19 June. On 17 June, an application was filed by my client praying for an adjournment for the day. On 18 June, an application was filed on behalf of my client. Accordingly, I am praying for a suitable date for hearing of the same. I have to request you that due to some personal difficulty, I will not be able to attend on 24th. Hence, you are requested to kindly grant a date of hearing 7 except 24th June. Please, this is 20th June. Now, my lord, this is my application where, my lord, starting from page 103.
Yes.
Till, my lord, till 246. I'm sorry, my lord. 245. This entire application proceeds with all annexed judgments. All annexed judgments which inter alia cover the issue of limitation also. Now, my lord, if your lordship takes the trouble to see the impugned order, at page 249,
yes.
my lord, after narration of facts, at page 2, my lord, this is 249, it begins. My lord, the order, in fact, begins from, final order begins from page 251.
Yes.
15 July 2025. After the narration of facts, my lord, then please see, he has narrated all these facts. He has taken into consideration the written notes of arguments of Sotto Doctor at page 253. In their reply as well as written notes, the Sotto Doctor welfare, this side as Okuba has claimed that the original lessee has, this is what has been considered the judgments of Sotto Doctor. Then, my lord, straightway, comes to page 255.
Yes.
OP in its oral as well as written applications.
Which portion?
This will be 255.
Yes, 255.
I'm sorry, 254, sorry, 254.
Yes, yes.
OP in its oral. Then, SMPK submission is quoted.
Yes.
Then straightway it goes to heart the rival contentions from both parties. Then takes the next page. Please see page 255. 255. Heard the rival contentions of the parties. My lord has very kindly got it. Then it appears that after conclusion of the instant hearing, the OP filed two sets of applications before this forum, one on 18th and another on 20th, seeking hearing for dismissal of the instant application along with allied prayer. I must mention here that the provisions of the PP Act, it is the primary duty of OP to file the reply or deal with the grounds mentioned in the show cause notice, and OP has already filed such reply, and now after conclusion of hearing, first pausing here, 17 June is the only date of hearing. There is no other hearing. After conclusion of such hearing, filing of application for further hearing by OP would only delay the matter and eventually defer the administration of justice. Hence, I find very little merit in the application dated this and this, seeking opportunity of hearing. The OP was duty bound to file documents in support of the case, if any, against the show cause issued by this forum. And the PP Act nowhere compels the OP for its personal appearance, attendance, etc. All that is needed is the reply to the show cause to be filed within the statutory time of 7 days, within the supporting documents in support of the case. And it is needless to mention that taking up adjournments on one pretext or the other frustrates the basic spirit of the Act. Hence, such application is rejected. After careful consideration of all relevant papers as brought before me in course of hearing and after due consideration of all submissions made, this is the issues. The issues which have been raised inter alia, issue number 3, he has said whether the proceedings are barred by law.
Limitation.
While considering it, please see whether he has even taken the trouble to even go through any of my judgments relied on in the application. Please see, he has considered issue number 3, 4 and 5 are taken together. At page 8, internal page 8. It is at page 258.
Yes.
That is page 258. And this is how he has decided limitation, I must say.
Yes.
And he rejects the prayer by relying on judgments. At page 260, ultimately he holds that the applicability of the Limitation Act before a quasi-judicial authority, the subject matter of concern before the Honorable Apex Court by the judgment delivered by the Honorable Apex Court in MP Steel, emphatically observed, this is what he has quoted in its entirety. And ultimately at page 262, he has rejected. Yes, it does not apply regarding applicability of Limitation Act.
Yes.
Now please see, in my application, I had relied on, at page 205, a judgment reported At page 205, a judgment reported in 2010 for CLT 591. Where in paragraph 58. This is what has been held.
Yes.
Then, my lord.
Paragraph 58.
Then, my lord, the next one, 2015 SCC Online 8332. It's a civil divisional application where the issue of alternative remedy and everything is taken into consideration from at page 222.
Eight double 32.
Yes, 8332. Will not please see page 222. 222. Para. This will be para 20. No, 10. I was wrong. Now I am. Where, my lord, the previous judgment is taken into consideration and it has been held. In this case, also the question of time-barred claim under section 7, as well as the question of invoking the jurisdiction of this court under 226 was involved where the petitioner did not avail the statutory remedy of appeal. On the latter point, it was held. My lord, this is what was been held. And, my lord, paragraph 11 may kindly be looked into.
Yes.
This is what the Honorable High Court has held. Questions of breach of natural as also expressive violation of provisions of law is involved. On the aspect of non-adherence to the principal argument of the petitioner, the only point of the petitioner is the claim being time barred. But the estate officer had disposed of the entire matter, holding the petitioner liable to pay damages. I have heard the parties at length on this point. In the case of such and such, the Supreme Court had accepted the proposition of law that the power of jurisdiction under Article 227 could be invoked to challenge the validity of an order, even if there was a provision for appeal against that order. The Supreme Court in that case, however, was pleased to set aside the order passed by the High Court invoking such jurisdiction. In that case, such and such also, the Supreme Court dealing with jurisdiction under 226 held that where there is an appropriate efficacious remedy, the writ court should keep its hands off. But none of the authorities cited by Mr. Basu lay down as an absolute proposition that jurisdiction of the High Court under 226 and 227 of India ought not to be exercised at all if there is an alternative remedy available. This being the legal position in the given, I do not want to take a different course of action. Case had been made out at the prima facie stage for intervention of this court invoking 227. Points that have been urged before me relate to questions of law only. In a case of this nature, principles guiding invoking jurisdiction of Article 226 ought to be similar to a case under Article 220. Thus, I reject the objection on the ground of maintainability of the writ petition. This is then, my lord, paragraph 13 may kindly be looked into. I have also been addressed by the Learned Counsel and the Port Trust on the question of legality of the claim of the Port Trust for damages. Main case of the petitioner on this point is the alleged debt relating to the period starting from such and such to such and such is barred under the statute of limitation. The stand of the petitioner on this point is that the demand for damages, if any, can relate back to 3 years from the date of issue of notice under 7.2 and 7.3 of the 71 Act and not beyond this period. Substantial argument has been advanced before me on this aspect, and the authorities cited on behalf of the parties in this case includes Milord Kaluram, 76 Supreme Court 2446. and other judgments may not have been on behalf of the Port Trust. It has been the provision of Limitation Act do not extend to the 71 Act, and the limitation period for instituting a suit for recovery of money as contained in the first division of the Schedule to Limitation Act only relates to institution of suits. Their stand is that a proceeding under Section 7 cannot be equated with a suit. The petitioner, on the other hand, argued through their counsel the law of limitation applies to a proceeding under Section 7. The petitioner wants application of Article 87 of the first division of the schedule to argue that the claim of the Port Trust, if any, has to remain confined to this article. One of the points on which the petitioner sought to invoke the jurisdiction of this court under 227 is the petitioner had filed 2 applications for dismissal issued under Section 7 similar to our facts. But the estate officer had determined the question of grant of damages on merit. This has been pleaded in such and such paragraphs. No trust, there is no effective denial. No doubt it should be, effective denial of the statements made by the petitioner in the impugned order, as also there is reference to the nature of the petitions which were filed. The estate officer, however, has determined the validity for claim of damages on merit. In my opinion, for this proper purpose, another opportunity ought to be given to the petitioner, and both the proceedings instituted by the notices under this and this ought to be reheard by the estate officer on merit. There is no indication in the order as to why the matter was decided on merit on the claim of damages. The proper course should have been to dismiss the 2 petitions filed by the petitioner. Here, the estate officer, in the facts of my case, has determined the applications without even batting an eyelid, my lord, as to why the case pleaded in the applications and the judgments relied in support of the applications were not found to be tenable and creditworthy. He has merely rejected by relying on judgments which do not deal with estate officer proceedings or PP Act proceedings. He has said quasi-judicial authority, applicability of Limitation Act and exception. Whereas judgments stare on his face.
Mr. Bhattacharya, can you give better copies of these judgments, because this
yes, 100%.
The photocopy which has been made, I think micro or something, so it has been.
I will. All the judgments relied on. Very well, I will give it.
This too, because you will be finding it difficult.
I will be,
those lines are very.
I will be giving it to this morning.
Please come to the order passed by the. Please, one thing before you make your submissions on merits, please kindly come to the impugned order once. Now, with regard to the limitation, it has been held that in a proceeding of this nature, the Limitation Act is not applicable. Please kindly come to the decision of the Honorable Supreme Court relied upon in this judgment, which Mr. Bhattacharya has just now placed. 2 decisions. The second one is 2015 SCC online, which takes note of the Supreme Court judgment, considers Section 7 and says Limitation Act has to be considered. So this is against this. This was not considered.
May I just in my own way, my lord, just assist your lordship for 2 minutes, my lord. First, my lord, he said, my lord, only on 2 reasons they said. One is, my lord, that there was violation of natural justice. And second is patently. My lord, kindly come to page 256. 256, my lord, 2 lines, Mr. Bhattacharya has not been placed. It's clearly written after the application was heard. 256. After careful consideration, just before that, 2 lines. Be that as it may, following the principle of natural justice, I proceed to consider the case made out by OP through its applications already on record. So that is not the issue. His application was summarily rejected or not at all considered. The issues thereafter that was recorded is outcome of the issues that he has said. Now, one thing, kindly have a look at Rule 8 of the Public Premises Rules of eviction. Of course, hearing is necessary, but in case of damages, the yardstick is different. kindly come to
No, hearing is necessary.
hearing, my lord, the yardstick. I am telling that, my lord, in case of eviction, there may be different question can crop up. Assessment of damages. So this is under section 7 rule, my lord, is the damages. Now, lordship says, in assessing damages for unauthorized use and occupation of public premises, the estate official shall take into consideration the following matters, namely, the purpose of period for which public premises were in unauthorized occupation. Has the lordship got that rules? 2, the nature, size, standard of the accommodation available in the said premises. The rent would have been realized if the premises had been laid on rent on unauthorized occupation to private person. Any damages done to the premises, any other matter relevant for the purpose of assessing damages. So the question that a hearing is necessary, a full-fledged hearing with evidence, I say, my lord, the rules is very clear, is not necessary. And the application which he says is not considered was duly considered as it reflects from there. Now, my lord, kindly come to the limitation portion.
So according to you, if the application is filed, no hearing is necessary. If you consider that, that is sufficient compliance of the principles of nature.
Yardsticks that given in the rule has to be followed, and for that, my lord, lordship, the difference is now my lord, just segregate that with rule 5, which says, my lord, that Mr. Bhattacharya placed. So I say holding inquiries. So I say my understanding of this is that the 5 for inquiry is for, my lord, in respect of.
Then, Mr. Nag, no, there is no necessity of participation of the unauthorized occupation, unauthorized occupants while deciding assessment of damages. You can assess your damages in your own way.
No, I can no, my lord. I am sorry, my lord. Here, there was a show cause notice. There was a reply.
There was no necessity, Mr. Nag.
Formal hearing.
If the hearing is not necessary, they have no right. What is the necessity of issuance of show cause notice also?
Saying that hearing is not necessary. I say there was a show cause, a reply was given, and that was considered hearing.
So no hearing is necessary.
And 2 applications were also considered because the 4 yardstick we have to follow. Well, a hearing as a matter of fact was given, and it was considered, and therefore, my lordship will find. And also, my lord, 255, it is clearly says that hard the rival contention of the parties. Well, lord, what happened?
Then also in revisional courts and other things, Mr. Nag, once an application is being filed, no necessity of hearing can be decided. Parties can be directed to file application and the affidavits. Court can pass an order after cause. Because that is also scope is very limited because court is adjudicating an order passed by an learned trial judge or the appellate court, whatever it might be. The order is there, the challenge is thrown, other side may be asked, yes, you file your affidavit, can be decided. Sir, now that is stretching too far. The principles of...
255.
Yes.
Heard the rival arguments for both the sides.
Where is the argument? When you have heard? When? Show me the date when you have heard.
When on 17th, when he was there. When he was there, he had the opportunity.
Show me
He
that
had
you have...
the opportunity. He did not argue on that day.
Show me that this was a date fixed for hearing of these applications.
But on 17th, when he was there,
maybe Mr. Nag, maybe a person may be there. Show me that was a date fixed for hearing of these applications. Show me.
In January, lordship, 17 June. 17 June.
Yes, show me page.
It's 101.
101.
Yes.
In this scene apart from
101. 101. But 101, the matter was fixed on that day for hearing.
Had placed their verbal submissions. Mr. Bhattacharya, on 17th of June, you have made your arguments.
Thereafter, I indicated, on the 17th itself, on PC page 100.
Yes, but 17th you made your arguments.
Yes, I did participate and I said that I intend to come with 2 applications. Kindly grant me a short date. Now, please see my application, page 99.
Yes,
Please see page 99.
today, today, this is on 17th June.
Yes.
Has appeared in the
That's
proceeding
that
at
is
some
the
time
first date.
to file application before this estate officer.
Yes. Seeking adjournment of today or for a short period.
Yes,
enabling the
you
open
sought for an adjournment, but
Yes.
you made your submissions.
Yes.
You made your submissions.
But only.
Place the respective verbal
No,
submissions. Place the
my
respective verbal
instruction
submissions.
is,
Has
Mr. Dasgupta was there. He did not make any submission. That was the
It has been
first day.
recorded, Mr.
Recorded.
Bhattacharya.
It is recorded. If it is wrongly recorded, the fact also remains that an endeavor was made filed 2 applications, and in fact, both the applications were granted. I had filed the application on 18. I did not, wait for an indefinite period of time.
No, Mr. Bhattacharya, please kindly come to page 101.
Fine.
After the 3rd paragraph, had
But
also
even in the
filed an
first-
application seeking adjournment to file an application before. Peruse the application. Consider it is seen from the record that both the opposite had filed their respective reply to the show cause. You have filed your reply to the show cause.
My lord, first paragraph, lordship sees verbal submissions.
No, but only one thing, Mr. Nag, they have filed 2 applications.
Lordship.
You have
After that.
yes, after this, after 17th of June, on 17th of June, they have paid for an adjournment. But according to you, according to them, they have not made any submissions. According to you, they have made submissions. But the fact remains that they have filed 2 applications thereafter.
Thereafter, and that was also considered. That's
Show me
what I said.
that this application, a date was fixed for hearing.
My lord, lordship sees. My lord, kindly have a
This application,
my lord, kindly have a look. In this penultimate paragraph, it is needless to mention that here in Public Premises Act provides a procedure, my lord, penultimate paragraph of 101. Procedure for speedy and summary disposal of cases.
Please give me a minute. 2 applications. One is at page 103,
which was on 18th June, and one on
filed on 18th of June.
18th of June, one is on 20th June. That is also
18th of June 20.
One is 18th June and
2025.
Yes, and
this was one application.
And
where is the other application?
18 June application of one page.
না 18 জুনের অ্যাপ্লিকেশন মানে 103 103 is one the forwarding letter. 100 is one application 18 June and 102 is the second application. On 20th June, the entire application begins from 103, ends at page 243.
So this is the substantive application. 103 is the substantive application.
Lordship.
So this is the application for dismissal.
Yes.
Mr. Nag, whether any date was fixed for hearing of this application?
No, if it is not there, it is not there.
But according to you, this application was considered.
Considered and it is reflected in the order.
Yes, yes. But now what was the point raised? One of the point
is limitation that was in the show cause reply to show cause limitation.
Yes. Now
application is also limited.
How you have dealt with the limitation point? Please kindly come to
now
page 260.
Lordship.
Or you can come straight away to the ultimate conclusion on the limitation at page 262.
Now, my lord, 2 applications was considered. Lordship will find at page 255. And my lord, it was hearing concluded and thereafter written notes of arguments was directed to be filed. That is also page 101. Then, my lord, kindly come to the limitation portion.
Yes.
Is at page 260.
What is your finding on the limitation?
Limitation, my lord, my submission is clear, my lord, before your lordship. Lordship may, my lord, it can be said, my lord, the reason given is, my lord, maybe not sustainable, maybe. Now, my lord, the question
No, but these judgments, decisions which Mr. Bhattacharya is now placing, those were placed before the estate officer.
Yes, and that
Show me that you have considered that.
260, page 259, last 2 lines.
Yes.
The judgments of different high courts. Lordship sees the last 3 lines. PP Act, it is futile.
Yes.
To advance any argument for its application.
The judgments of different high courts, including Delhi High Court, could be accepted as a guiding principle in this connection. I am fortified by a judgment of Honorable High Court in such and such, with reference to such and such, wherein it was clearly held, proceeding initiated by the initiator are not of a nature of a suit, nor the estate officer act as court while deciding the matter. So the earlier judgment was negated and was substituted by another judgment and also the judgment of the Supreme Court. Now, my lord, pausing here for a moment, now, my lord, the judgment I place before your lordship, my lord, there can be two views in the matter, may be erroneous, but that cannot.
No, show me what is the other view on PP Act.
Lordship, then, my lord, oh, I'm sorry, I just skipped to that. My lord, kindly give me a moment. Now, my lord, here, 260, my lord, lordship, I was placing.
Yes, 260.
260, the applicability of the Limitation Act before the quasi-judicial authority like forum was subject matter was considered before Honorable Apex Court of India. By the judgment delivered by the Honorable Supreme Court of India in such and such, it was empathetically observed in paragraph 16. Well, paragraph 16 place that.
Where is the decision? 2015 7 SCC 5 page 5.
Then, my lord, then there is no scope. My lord, after the quoting, there is no scope of deciding the matter. Otherwise, after observation made by Apex Court in such and such in paragraph.
So was this 2015 volume 7 on Public Premises Act?
No.
Then
no.
That was a direct decision on that issue, public premises.
Lordship is absolutely correct. All I want to say, in alternative remedy, they have to show this is patently illegal, natural justice. Natural justice I have taken care of. Number of the
Natural justice,
I
one thing.
placed, 2003.
Applications, Mr. Nag, that no date was fixed for hearing.
No, my lord,
You may have considered that.
After hearing, my lord, he filed the application. My lord, kindly the judgment I placed before your lordship.
Yes.
3 volume 675.
But Mr. Nag, there are two aspects. You may say, no, since after hearing, you have filed 2 applications, I will not consider
No, I
that.
have not.
Then, if you have said that, yes, one thing. Yes, hearing after closure of argument, I will not. So now you have entertained. Once you have entertained, this is a point which he has raised. Limitation going to the root of the matter. Ought to have given them.
Also disclose, well, 2 line I will say on merit after I close this. Well, kindly have a look at my judgment, 2003, volume 6, 675. I have placed before your lordship on other day. One paragraph. I want to show a patent error or patent illegality is what? Well, not warranting jurisdiction under article.
Sir Nag, this judgment, what is the fate of this judgment subsequently? Surjadevi Rai?
Surjadevi is no longer there.
Yes.
Diluted.
Even diluted.
No, it has been diluted.
Completely,
And the main proposition is that
gone. It's gone.
Surjadevi Rai.
I just want to
perhaps overruled to
I
an
just
extent.
want to give a explanation of what is patent data. Well, patent data is at 38 volume 6, subparagraph 6. A patent error is an error which is self-evident. Well, this is just this ratio I am sure as well.
But Mr. Nag, this judgment has been diluted, it has been overruled.
Just give you a lordship the citation.
I will tell you, lordship, kindly come to page paragraph 6, subparagraph 6 of paragraph 13. Page 695. Patent error is an acceptable legal principle.
So you cite other decisions, Mr. Nag. This
I will
judgment has
show
been.
different judgment before you lordship.
Yes.
Well, just for the sake. Well, what is?
Show me 2015 7. 2015 7. Mr. Nag, there are 2 things.
I am showing. Well, before that, just one paragraph
Of.
that judgment of 38 of Surjadevi Rai.
Yes.
6, well, page 695. A patent error. That's what my submission. Takes that. A patent error is an error which is self-evident, which can be perceived or demonstrated without involving into lengthy or complicated argument or a long drawn process of reasoning. Where 2 interference are reasonably possible and the subordinate court has chosen to take the view, the error cannot be called gross or petty. So, my lordships here, he is saying, I also think, to some extent, Maybe the view which Mr. Bhattacharya is saying is correct, but the fact remains, my lord, I have taken a view different, maybe is not sustainable. Can it be patented, warranting interference? I tell you, your lordship, and why not? My lord, kindly have a look to their civil revisional application. My lord, what they were doing, they were not running any business. My lord, kindly come to their cleaning. Kindly come to player cleaning, page 13. Page 13. Well, what they did, they, my lord, inducted subtenants.
Mr. Nag, I am not on merits. I have not entered into the merit.
Lordship. Now, my lord,
there are two aspects, because the scope, as you have enlightened the scope, that is very limited under Article 227.
My lord, kindly have a look at
One of the thing is that failure of the natural justice. So that is one part, and how
my
the
lord,
decision which was
judgment that the learned estate officer looked in. Can we
Yes.
come to paragraph 19 and 21?
Paragraph
19 and 21, which I think the possible reason for coming to that conclusion.
Paragraph 19
Paragraph 19
and
21. Well, may I place these two paragraphs? When it comes to applications, again, article, when as your lordship got that, 19.
Mr. Nag, whether this judgment which was relied upon, that has been considered. Yes, Mr. Bhattacharya, what was your Supreme Court decision which was taken into consideration in that?
Kaluram.
1970. Kaluram. Kaluram has been separately handed over, I am told.
No, was this considered here?
Kaluram.
Yes.
Yes.
No, our judgment.
76.
No. In Milord Justice Basu's judgment, Milord, it was considered.
What is the decision? What is the reference?
No, just give 2 minutes.
1976, 3SCC 407.
1976.
3SCC 407. It copied.
Kaluram is two judgments.
My Kaluram is 1976, volume 3, SCC 407.
So this was not considered.
It was not considered in the 3 judges bench, Ballot. No, it's also 2 judges. Well, kindly have a look at paragraph 19.
Yes.
When it comes to applications, again Article 124, 130 have throw a great light. Only review of judgments by a court is competent in the 3rd division in a schedule. Further, if to appeal as a proper again can made to High Court only for Article 130 and Article 130 division petition filed before court such and such. On a plain reading of the provision of Limitation Acts, it becomes clear suits, appeal and application are only considered from limitation point of view if they are filed in courts and not in judicial bodies. So 19 and 21, under constitutional scheme, the judiciary is dealt with chapters such and such where the constitution uses the expression court, which refers to court system. As opposed to court system, a system of quasi-judicial body is called tribunals. Thus, Article 130 refers to court as distinct from tribunals. The question in the case where the Limitation Act extends beyond the court system mentioned above embraces within the scope of jurisdiction as well. Then Malad went on saying that the Limitation Act will not apply in respect of tribunals. Maybe Malad, this judgment has not considered the Kaluram's case, but the fact remains, Malad, this is also can be a plausible view, and which requires to be Malad a detailed adjudication before Malad the trial court under section 9. Because the issue here is also the tenants, if inducted by them, they continued on paying in the name of Martin Mark.
Well, only one interruption, and I am not disturbing my learned friend, only this much, Milord. At least this basic thing that we have learned from your lordship's court, Milord, that if a judgment is denied on, at least an opportunity is to be given to the party to at least meet the judgment. But in course of 17th of June, no one cited this judgment. On 17th of June, nothing, that judgments were not invented by, discovered by the learned estate officer.
So, you have annexed those judgments?
Yes,
to your
application.
Mr. Nag. They ought to have been given an opportunity to deal with this. Could not have relied upon this.
Oh, they have not given a 1 minute.
And these judgments will not be, the learned estate officer has relied on, was not cited.
Consider, Dr. Nag, consider all these judgments, because these judgments were not given to them. They did not get any opportunity to deal with.
I don't know in the written notes of arguments whether this judgment was.
What written notes?
Well, I don't know what.
You will not give written notes to them. You are the officer. You will give written notes.
Not me, my lord. Before the tribunal, what happened, I don't know.
It's not a matter of dealt with those. I'm not saying you. I'm saying about the. I'm not meaning you.
Well, there was a rejoinder file. I have to check and come back whether the judgment was handed over.
না 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 দেয়নি গো দেয়নি 1 মিনিট হিয়ারিং হয়েছে
Cannot be.
2 ঘন্টা বসে 1 মিনিট হিয়ারিং হয়েছে
Well, how can I see that? I don't know. He is submitting from the bar. I don't know how long the argument went on. I don't know anything.
No, no.
But
This-
once
this-
you know what.
all right. No, that you can take instructions and come. There's no difficulty on that, because it prima facie appears that they did not get any opportunity with regard to these decisions.
SMP.
They have cited some decisions.
Both against OP argues that the purported made in reply are not tenable in law. এটা rejoinder দিয়েছে SMP.
That is the reason why Mr. Nag, an opportunity of hearing ought to have been given. Because you are deciding their applications, you have taken that. Now we are dealing with that applications by relying upon some decisions
Answer
behind
will-
their back.
My answer, my lord, to the what has fallen from your lordship is that, my lord, on my lord, the eventful day when he said, my lord, there was no argument. My lord, the hearing was closed with a direction to.
You could have rejected. You could have said, no, I will not.
With written notes.
Mr. Nag, why did you deal with these applications? You
My
could
lord,
have said, no.
it says, my lord, for the sake of natural justice.
Yes, now.
She is complaining.
Now, when you are deciding that, Mr. Nag, it was incumbent upon you to give him a hearing, because filing of an application, you have relied on this. At least when you, being an adjudicating officer, you have found some decisions have been cited, and according to you, yes, there are contrary decisions. Was it not?
But it's not always, my lord, lordship is absolutely correct. But here also we don't follow this, my lord. My lord, if we file written notes, the copy is not given to. My lord, in the written notes, maybe the judgment was given, because 101, my lord, the order is clear. My lord, the hearing was closed and parties were given
Mr. Nag,
direction
that
to
you
file.
have relied upon that, you cannot deny, because you have considered their decisions. You have considered their decisions.
I have considered
So that they have given, you cannot deny that.
Lordship.
But only thing is that whether you have given them opportunity to deal with the decisions which according to you, or you have relied upon that, because they have to be given an opportunity with regard to that.
But my lord,
Maybe you have a right to follow one decisions to disregard another.
that's
I mean, like
not-
the citation where,
This is the usually which is being followed here also. If they, let us suppose in reply, you rely upon some decisions, though there is no reply to a reply, but if you cite a new decisions, other side is given. So why it is only because it is
since I will request my learned friend, Milord Radhesham versus Shobinath is the judgment where Milord Suryadev Rai has been partly overruled. That is 2015 5 SCC.
That was with regard to Mr. Bhattacharjee,
227,
226
yes.
and 227,
That point.
226.
Correct.
So
That
And the
point.
judgment you submitted is on 226, article 226.
Whatever, Milord, the thing is.
So Suryadevi Rai, yes, had been Suryadevi Rai has been. What is the expression? Overruled, or it has been explained? I think some portions have.
I'll just show you a lordship, Milord.
কোথায় বলছো ওভার
দাঁড়া বাবা ঠিক করিস না overruled on.
It has been overruled.
It has been overruled.
Patent error was
25, 20. I'll just show you a lot.
Observations, paragraphs have been overruled. With regard to 226, writ of certiorari,
Oh, same. Oof, sorry.
One point, my lord, which I argued today before your lordship, that rule 8, my lord, is, my lord, substantially different, my lord, in respect of assessment of quantum of damages.
Of course.
It has been overruled in
2015, 5 SCC, my lord, I find it out. Found it out.
in
My lord, can you-
2015,
5 SCC.
5 SCC page.
খুললাম এবার। এসে গেছে।
নতুন সিস্টেম
Overruled on this point.
Yes. You know, I will, you know, check this and come back, you know.
Yes.
Which point?
It's on 226 when writ of certiorari can be exercised.
Yes.
On that point, it has been, if my memory serves me right.
My lord, I will also check it, but my lord, prima facie, my lord, whether an order passed by a tribunal can be a subject matter of a 226 proceeding. That was the issue on which, my lord, this point was decided.
Yes.
Because, my lord, those lines of decisions, my lord, appellate authority of the board, whether it is amenable to 227 or 226, those decisions, my lord, came up for consideration before my lord's court. Give me a number. বন্ধ করে দিচ্ছি জীবন।
All right, check it up.
Yeah, I'll check it. I'll give a side, my lord, copy. I've handed over, my lord, Justice Basu's judgment. The other one, my lord, I shall also take a print and give it to your lordship. Your lordship is kindly keeping it, my lord.
Yes, Mr. Nag.
কালকে?
Only on this, if that was not given,
ये तो सबसे
that has to
কালকে
be.
হয়ে যাবে।
Lordship keeps the matter tomorrow, I will take instruction in the week.
Tomorrow.
Instruction in
Tomorrow same time, my lord. Tomorrow কি আছে? Next date of hearing. Yeah. In the meantime, my lord, the to 42, particularly paragraph 42.
Mr. Bhattacharya, do one thing.
I'll give a compilation.
Yes, give a compilation.
All the judgments. Hey, Priyanka.
I think that will be.
পরশু 3:30 আছে 3:30 সময় don't listen to this. We lot of our learned friends know.
No, I know, my lord. On Wednesday and Thursday, both 3:30.
But my lord, our matter is fixed before Justice Tirthankar Ghosh, and now your lordship is also, my lord, from, my lord, 5 o'clock, 5:30 matter.
3:30, well. I know it because I asked.
Okay, tomorrow kindly keep it. Kindly keeps it tomorrow.
Tomorrow at 4. আর কালকে কি বার? Tomorrow.
চচ্চর কি কানে শুনছিস?
এটা ড্রাফট করা